ऐसे accident हुई देखले तो ঠিক এই গীতাঞ্জলি বা
এখানে কি লাস্ট করব Welcome back to the second session of the annual State Stakeholders Consultation on Child Protection organized by Juvenile Justice Committee, Guwahati High Court, in collaboration with State Child Protection Society, Department of Women. In this session, we'll have the presentations from the participating states of Assam, Arunachal Pradesh, Nagaland, and Mizoram. This session will be chaired by Honorable Mr. Justice Manas Ranjan Pathak, Judge, Gauhati High Court. Each state will be allotted a time of 10 minutes to submit their presentation.
Before beginning with the state presentations, I would like to request Honorable Mr. Justice Manas Ranjan Pathak to kindly give a brief introduction.
Namaskar and a very good morning to all of you. This 8th round of state stakeholders consultation on child protection, on children in conflict with law, prevention, restorative justice and diversion and alternatives to detention. We all know that when a board or a committee directs a child to be kept in a special home or children's home, it's not amounting to the sentence to that child. Normally, the keeping a child in a special home or a children's home is the last resort until we find a community carrying some organization. We need for the development of the restoration and the development of the child, so he can back to the society as a good citizen. Now, what we have seen, that for that purpose, we have been holding all these consultations, and every round of consultations, many things are coming out. We are benefited from that, and today also we are looking forward from the participants and the presentations they are to be given herein, so that we know during the last all these 7 consultations, what they have done and what is in their plan in future. So at first, I like to call the representative from the state of Arunachal Pradesh to give their presentation, but at the same time, I'll just a gentle reminder, the minutes only 10 minutes to be given to the participant. So please start.
Srimati T.P. Loi, Director Secretary, Women and Child Development, Government of Arunachal Pradesh, is now requested to come to the dais for the presentation of the State of Arunachal Pradesh.
Good morning to all of you. Honorable Mr. Justice Manas Ranjan Pathak, Judge, Guwahati High Court on the chair, and all the honored dignitaries of the dais. I am Srimati T. Pertin Loi. I am the Director, Women and Child Development Department, Government of Arunachal Pradesh. Our team is headed by our Secretary, Srimati Mimum Taeng, and we have also our Chairperson of the State Commission for Protection of Child Rights, Srimati Gumri Ringu, the representatives from Child Welfare Committees, and representatives from the Department of Health, Education, and from the police. Coming to my presentation, sir, this is just in very brief about the status of juvenile justice system in Arunachal Pradesh. We have 26 child welfare committees in the state, including 1 in the capital region. We also have 26 juvenile justice boards in all the 25 districts of the state, as well as 1 additional for the capital region. And we have 26 special juvenile police units in each district, including the capital region, and 11 child-friendly police stations in the state. We have the District Child Protection Unit in 22 districts of the state so far, sir, but for the remaining 3 districts, the establishment is underway. The 7 district and session courts and 1 additional and district court has been designated as the special court. We have 1 observation home, a special home, and a place of safety within the same premises of the juvenile home in East Siang District, Pasighat. And for the children in need of care and protection, we have 15 registered children homes, and 2 specialized adoption agencies. Sir, in Arunachal Pradesh, although the number of juvenile delinquents cases is not very alarming, but yet a matter of great concern, because over the years we have seen there is an increasing trend of reported juvenile delinquent cases in the state. So, to understand the crux of this juvenile delinquency in the state, we have commissioned the Rajiv Gandhi University, Department of Sociology, Rono Hills, Arunachal Pradesh, to undertake a study on the topic juvenile delinquency in the state, reason and prevention strategy. So this research is expected to be completed within 6 months by October 2023. So based on these reports, which will be submitted by the Rajiv Gandhi University, the Department of WCD will initiate further action and policies on the problem of juvenile delinquency in the state, besides the actions which we are already undertaking as per the Juvenile Justice Act and rules. So I'm happy to inform that Arunachal is one of the 9 states in the country which has already established the WCD control room of Women Helpline 1098, which is integrated with the Emergency Response Support Service 112. In the Northeast, only Arunachal and Mizoram has gone live on 7th of July, 2023. And so for the, in the districts also, we have already set up in 3 districts, that is Papumpare, Lower Dibang Valley, and Namsai district. And in remaining 22 districts, we have also identified the space for setting up of the child helpline. This is on the first theme of our agenda, prevention of child offending. Then, sir, as a awareness and prevention, we have also developed 2 videos on the POCSO Act and rules and circulated it all the stakeholders. And also we have used the social media forum of Facebook page to circulate these 2 awareness videos on POCSO Act and rules. Apart from this, we are also undertaking awareness programs of the JJ Act, POCSO Act, and on good touch and bad touch throughout the states through the district child protection units, to the educational institutes, to the Panchayati Raj institutes, to NGOs, CBOs, women organizations, Gam Buras, and the general public. And so we have also developed a monthly activity calendar for a year on awareness programs related to child marriage, child trafficking, POCSO, reporting of missing children, adoption, etc. And this has been circulated to all the DCPUs of the state. These are a few pictures of the awareness that we had conducted. Next is the theme, diversion, alternatives to detention, and non-custodial alternatives. So as per the JJ Act, there are 3 types of homes where the children are kept. These are the observations home during the pendency of the cases, special home once the child has been found to have committed the offense and placed by an order of the Juvenile Justice Board, and a place of safety where a child who is between 16 to 18 and has committed a heinous offense. And also there are others like alternative detentions for like a fit person or a fit institution or a probation officer, as the case may be or as ordered by the Juvenile Justice Board. Apart from this, under Mission Vatsalya scheme of the Government of India, a new concept that is an integrated home complex by the name Vatsalya Sadan has also been introduced, where all the homes, the children's home, the observations home, the special home, place of safety, including the offices of the JJBs and the CWCs, will be in a single premises. And for this, sir, we have already, the Government of India has already approved 2 Vatsalya Sadan for the state, which will be in Namsai and Pasighat. And so 6 more observations are coming up. These are a few pictures of the undergoing construction juvenile homes in Arunachal Pradesh. So this is just a data of the children who were admitted in the homes and the children who are released. And at present, we have 6 inmates who are currently housed in the observation home at Pasighat. I'll just run this thing. Then, for children in need of care and protection, we have 15 children homes, 2 SARs, in total 17 child care institutions in the state, in which presently 155 children are housed. These are the names of the various children's homes and the number of children which are housed. Then this is a report which source is police headquarters. As per the trend, we can see that the total cases of registered juvenile delinquents is on the rise, and the percentage of overall criminal cases is also increasing since 2020 to 2023. Initially 2020 it was 0.72 and presently 2023 1.08. So this is the status of the pendency of cases before the Juvenile Justice Board for the last 3 years and of the first quarter of this year. Total cases 421, cases disposed of 45, and the number of cases pending is 376. Now coming to the rehabilitation and restorative practices. So there is a provision of aftercare for both the children, whether it's children in conflict with law or the children in need of care and protection. After attaining the age of 18 years, they are given this aftercare facility, and a financial support of 4,000 per month is provided till the child is fully reintegrated into the society. And so far, 5 CNCP children has been assisted. Other alternatives of aftercare guidelines is that under JJB, a one-time grant just to start up a small business is also provisioned. We have this Arunachal Pradesh Juvenile Justice Fund rules. And the Government of India also, as an innovative program, has provided us with computer sets and embroidery machines to provide vocational trainings to the children. Apart from the vocational trainings that are already provided in the observation homes, special homes, and the place of safety as per their educational level, so as to enable them to come back, rehabilitate, and integrate into the mainstream of the society. I just like to share a success story that one female CCL was provided a government contractual job as a housekeeper, and she's working in the lone juvenile home in Pasighat. And as I've already said, the aftercare facility providers are 5 NGOs. The list of the NGOs is in the screen. It had been approved by the government. Then, so right to a fair trial and child-friendly procedure, including legal and other appropriate assistance, for which all the proceedings are done outside the court premises. The statement of CCL is recorded in camera, and all confidentialities are maintained. No photographs and other details are, all these are all not made public, it is kept confidential. And we have 11 child-friendly police stations, and the district child protection officers also has been instructed to maintain a list of interpreters, translators, and support person as per the JJ Act and POCSO Act, and they are provided a fixed remuneration per appearance. So as a part of the fair trial and child-friendly procedures, these are a few pictures of the child-friendly police stations and the JJB office. And apart from that, assistance is also provided by the SALSA. There are 20 retainer lawyers which has been appointed. This is the list of the retainer lawyers in 20 districts of the state. Regarding the minimum age and the age of criminal majority, the minimum age, as we are all aware, that it is not defined in the JJ Act, but in case of heinous offense, as per the JJ Act, it's 16 years, and as prescribed in the JJ Act, preliminary assessment is done by the JJB with the assistance of experienced psychologists to assess the mental and physical capacity of the child who has committed the offense. But as reports have been received from JJBs, there are challenges. It is one of the challenges is unavailability of psychologists or psychosocial workers in all the districts of the state. And secondly, there are very few psychologists in the state hospitals who are unable to provide assistance to all the JJBs in the state. So with this, I'd like to end my presentation. Thank you very much.
Thank you, Ms. Pratim.
Thank you so much, ma'am. Srimati Akumla Longchari, member, Nagaland State Commission for Protection of Child Rights, is requested to kindly deliver the presentation on behalf of the state of Nagaland.
Yes, who is representing Nagaland?
A very good morning to all of you. Respected Chairperson, Honorable High Dignitaries from High Court, organizers of the program, ladies and gentlemen. I am Erko Khrile, Program Officer from Department of Social Welfare. I'll be presenting for the state of Nagaland. First of all, like the letter have sent, children in conflict with law, prevention, restorative, justice, and diversion, and alternative detention. So, next slide, please. Okay. So, my first slide is the prevention of child offending. Firstly, we have to get identification of vulnerable children and those at risk, identification of vulnerable places, areas, or communities, preventive measures to be more measures by more awareness generation and education institution, Angawadi centers, churches, and local communities. Attempt of early and speedy intervention, together with the help of communities. There should be strict policy in places to prevent employment of children in occupation which expose them to social vices. Effective and alternative measures to deal with dropping out of school, collaborating and convergence with different allied government departments and NGOs, civil bodies working for children. Now, let me talk about diversion alternatives and detention and non-custodial alternatives. Section 12(1) of Juvenile Justice Care and Protection of Children Act 2021 When any person who is apparently a child and is alleged to have committed a bailable or non-bailable offense is apprehended or detained by any police or appears or brought before a board, such person should be, notwithstanding anything contained in the Code of Criminal Procedure 1973, 2 of 1974, or in any other law for the time being in force, be released on bail with or without surety of or place under the supervision of probation officer or under any care of fit person, provide that such person shall be so released if there appears reasonable ground for believing that their release is likely to bring that person is into association with any kind of criminal or exposed the said person to moral, physical, or psychologically danger, or in person released would defeat the end of justice, and the board shall record the reason for denying the bail and circumstances that lead to such a decision. The Section 12(1) JJ Act is often overlooked while dealing with children with conflict with laws, and it need to be implemented more effectively. Another diversion and alternatives to detention and non-custodial alternatives, community services as an alternative, JJB members need to be thoroughly trained and given more responsibility by the principal magistrates. Now, rehabilitation and restorative practice. The objectives of JJ Act is to reintegrate the child into mainstream society, depending on the age of child, nature and circumstance of offense, family, institution, and future goal. Therefore, in the state, there is dire need for provision for vocational training, bridges, education, life skill education needs to be provided in CCIs, especially special home and place of safety. Trained counselors, psychologists required in the institutions and DCPUs. Now, right to fair and trial and child-friendly procedures. Separate magistrate trained in JJ Act for JJB would be idle, especially in district like in practice to Nagaland, Kohima, and Dimapur. As JPU need to be trained in all the detailed procedure of dealing with CCL and CNCP. Often the SJPUs and magistrates are appointed holding dual responsibility, which has an effect on the quality of work. A minimum age of criminal responsibility, separate procedure for dealing with children between 16 to 18 years, irrespective of nature of offense. Institution for 16 to 18 years old required most stringent security, better convergence with legal services authority for faster delivery of justice to the children. Let me talk about the good practices that we have done in Nagaland. In Nagaland, a child in conflict with law, most of the time is also a child in need of care and protection. Therefore, the individual treatment is given reformative and restorative nature. A recent ongoing cases in Nagaland where a 14-year-old child in conflict with law has been sent to childcare institution. The DCPU Zuneboto, having assessed his need, psychologically and social background, has gone beyond their call of duty and is paying the school for the child from their own expenses. In addition to that, owing to the severity of the cases, since the child could not continue his studies in his current school and district as it became risky for his life, the DCPU has transferred him to another and district officers and the staff in collaboration with the school and the staff of the childcare institution is ensuring that the child continues his education in his current school by online mode and is being given in-house tuition by the staffs of CCIs. The notes, assignments, tests, and exam papers are being taken care of with the collective efforts of the DCPU, school teachers, and childcare institution. This child is also being covered under the sponsorship schemes. Meanwhile, constant counseling and for the child continues in the childcare institution. A way forward, as the overall objectives of the JJ Act is rehabilitation and social reintegration, all procedures providing full opportunities to give positive inputs to the child and plan for rehabilitation. Now, as stakeholders, it is our responsibility that all procedures are followed in letter and spirit of the GJ Act. Thank you.
Thank you, sir. We now have Srimati Sailopari Sailo, Deputy Director, Women and Child Development, Directorate of Women and Child Development, Government of Mizoram, to deliver the presentation for the state of Mizoram.
This one.
This is next.
Respected Chairman, respected dignitaries, honorable judges from High Court, and all participants, I'm Silo Pari, Deputy Director, standing here on behalf of my Secretary, Women and Child Development Department, Mizoram. Before coming to the main points, we have added a few slides. Just to give a gist of our situations and statuses with regard to the juvenile justice systems in Mizoram. We have 62 pending cases as of now, and the highest cases of juvenile, the cases that we have received at the Juvenile Justice Board is theft, and comes the NDNPS, under the NDNPS Act. I will go briefly to make the presentation short. And we have 12 observation homes in Mizoram, and we have 2 special homes and 1 place of safety. And we have 389 cases of juveniles sent to CCIs during April 2022 and 2023. And coming to our main points, prevention of child offending, we have conducted awareness and sensitization programs in schools, churches, and locals, and in various localities, and among young adults, parents, and communities. And we have disseminated print media and audio visuals in social media, and we have, and I'm also happy to announce that Mizoram is the first state to launch the newly automated child helpline in India, and in all districts, and it is now running, and it has gone live. We have gone live, and we have been receiving cases, and we hope that this will prevent and go a long way in preventing child offending. And regarding mapping of, and we have also mapped vulnerable communities in all districts of Mizoram. And to this, the main reason for this is to identify children in street situations to prevent child offending. And with regard to diversion, alternatives to detention, and non-custodial alternatives, we have received 367 cases during 2022, April 2022 and July 2023, and we have received 367 cases. And the children have been directed to go for counseling and they are allowed to go home for advice or after advice or admonition, and they have been directed to be released on probation for good conduct, and released on bail, directed to attend schools, directed to perform community service and attend therapeutic center. And regarding this, I would like to add that we have an innovative project under the Child Protection Services. We have the Child Guidance Center in Aizawl. So children, we have directed one child to go to the center to attend therapy in the center. And regarding rehabilitation and restorative practices, individual and group counselings are given, and family counselings are also given, so the children will go back to better environments. And we have set up schools in the campus of Aizawl Special Home in collaboration with School Education Department to provide regular studies for children staying at the CCI. And baking, tailoring, and computer classes are also given in the institutions, and we have been inviting in motivational speakers in the institutions, and aftercare programs are given. Children have been directed to go to attend trainings depending on their skills or their interest, like driving classes and baking classes and many other skill trainings. And with regard to right to fair trial and child-friendly procedures, including legal and other appropriate assistance, we have legal aid councils appointed in SLSA, DLSA in 8 districts, and we have child-friendly JJB rooms set up in all DCPUs, and we have set up child-friendly corners in 31 police stations. That is 57% of all the police stations. And we have SJPU set up in all police stations. And the children are not sent to police lockups, and no handcuffs are used while apprehending the children. And police officers wear plain clothes and not uniforms while apprehending the children. And these are the child-friendly pictures of child-friendly corners in the 31 police stations, an outpost in collaboration with the police department. And with regard to minimum age of criminal responsibility and age of criminal majority, the age group of CCL cases in the state, this data shows the age group of the CCL cases in the state during April 22 and July 2023. So we have a total of 326. And we have a suggestion from the state of Mizoram. We suggest that the minimum age of criminal responsibility be reduced to below 7 years, because we have cases where the juvenile is below 7. So, and regarding the preliminary assessment carried out during 2000, we have 11 preliminary assessments carried out during April 2022 and July 2023. And also we have a suggestion regarding the preliminary assessment of 16 to 18 years. We suggest that this may be revised, and this may be carried out depending on the cases, because there are children who are below 16 who have committed heinous crimes. So we suggest that this may be revised. Thank you.
Thank you so much, ma'am. Now, for the presentation by the State of Assam, we have with us Shri Parthopratim Muzumdar, IAS, Secretary, Child Protection Society.
Respected Chairperson of this session, Honorable Mr. Justice Manas Ranjan Pathak, Honorable Mr. Justice Ochinta Malla Bujarburua, Honorable Mr. Justice Kalyan Rai Surana, Honorable Mr. Justice Sushmita Khaunt Fukan, Honorable Justice Retired Mir Alfaz Ali, Director of the Judicial Academy, Sri Mukesh Sahu, Principal Secretary, Women and Child Development, my colleagues from all the states, police officers, judicial officers, members and chairpersons of the State Commission for Protection of Child Rights, and my dear friends. First of all, as the host, as a representative of the host state and having been a part of the organizing team, I welcome you to this forum, to this consultation, and I hope you are enjoying our hospitality, and we are trying our level best to provide the best of hospitality. Now, since we are a little short of time, I won't make my presentation too long. I'll be focusing mostly on the challenges. In Assam, we have, as of now, we have 31 districts and 36 police districts. So in all the police districts, we have the special juvenile police units. We have 33 functional district child protection units. We have 32 functional JJBs and 33 functional CWCs. So this is a breakup of this thing. And so this I have told. In the month of June, we started a 90-day campaign, which in Assamese we had named that Hurakhita Hoikhop Hunali Okhom, means a secure environment and a golden Assam. So under this, we have laid very special stress on many of child-related issues such as child marriage, child sexual abuse, substance abuse. Then we have reached out to all the districts in Assam, and from the feedback that we have got, that this has set a new precedent. I mean, we do have awareness workshops from time to time, but this has been a new experience for us. We had flagged off a number of vehicles, which carried the message that, we are not to indulge in child marriage, child sexual abuse, etc. Then this year, we have released 84 lakh rupees to the Juvenile Justice Fund so that this can be given to the victims of POXO cases. We have 5 observation homes. We have a special unit in Jorhat. We have a place of safety, but due to lack of, such kind of convicts after the amendment of the Juvenile Justice Care and Protection of Children Act, so we have one place of safety, but it is non-functional at present. This I have already said. So I will be presenting mostly on the challenges that we face at the field level, because I have been in the field of child protection now for almost 2 years, and these are some of the issues, which make convert a child into a CICL. Mostly it is peer influence, then dropout from school, parental negligence, lack of education, low awareness of the parents, broken families, lack of awareness regarding substance abuse, early childhood abuse, neglect, easy availability of drugs and alcohol in the market, and most importantly perhaps is the excessive use of smartphones and the internet today. Again, some of the challenges related to diversion and alternatives to detention. It is observed that in some cases, police personnel treat CICLs like actual criminals. In fact, I wouldn't like to name anyone. Even a child stealing a bread has to come before the court. I mean, these are things we can do away with. I mean, he need not come to court. It can be done. It can be disposed at a much lower level. As on today, we have an observation home at Boko, the capacity of which is 50. But due to, a number of children being, remanded to custody, we are at the edge, at the upper limit. I mean, on the other hand, we have 2 observation homes for girls at Jalukbari and in Nagaon. Now, these are empty. In Jalukbari, we have just 2 victims, and in Nagaon, we have just 1. Then, CICLs, who are found to be in need of, protective stay prior to production before the JJBs should be placed in a CCI. So these are some challenges. And another major challenge in Assam is the lack of de-addiction centers. I mean, we need to have more de-addiction centers. Again, what happens is once a child in conflict with law is released into the custody of his parents, these children, they do not like to continue their education further. And instead, the parents also, what they do is they engage these children in some other activities, like business activities or some other work, or send them to the agricultural field. Then some CICLs who are released on probation, they frequently change their addresses, and it becomes difficult to trace them so as to carry out their rehabilitation path. Then some CICLs migrate to other states because they too want to, lead a life of luxury, and that creates hurdles for us to rehabilitate them. Then lack of proper skill development, training centers, at the district level, this is another problem, a big challenge which we face, and the lack of de-addiction center I already stated in the previous slide. Then, these are again some challenges, like parents of CICL, they engage private advocates instead of, taking our help. Then JJBs, which are mostly in Assam, they are functioning from rented buildings. Now this prevents us from upgrading the infrastructure of these JJBs. Although from this year onwards, we are trying our best, and I will, in the later slides, I will show what we are trying to do. We are trying to have independent buildings for the juvenile justice boards. Then frequent transfer of police officials dealing with CICL cases is also a problem. Then lack of experts in the districts, and like my previous speakers from the other states had spoken about, this problem, that in the districts we lack experts. And we also need to impart more training to our police officers and my own officers, and we need some procedural guidelines as to assess the criminal responsibility vis-a-vis their age. Now this is the way forward which we are trying to do. Now in Assam, we have started providing sponsorship program for the CICLs. This we have already started from this year. Then mapping, like we need to actually identify these. Then we need, actually a lot with the public and private agencies to create awareness in some of the disturbed areas of the state. Then all POCSO courts need to be made child-friendly. I am sorry that till now we have only been able to provide child-friendly infrastructure, child-friendly environment in 16 district courts. I believe by the 2025 March, we will have child-friendly environment in all the POCSO courts. Then we need more and more drug de-addiction centers. We need to reserve some seats in the schools, colleges, and vocational institutes for the CICLs who are eligible for the purpose. We need more skill development centers, and as I said before, we need guidelines to be framed for the preliminary assessment of the child in conflict with law by the JJBs. Then we need establishment of observation homes particularly in the border areas of Assam and in the school districts. Then these are some of the achievements we have done. I'll just take just one more slide. These are some of our promising practices. 7 CICLs were enrolled in formal residential schools for continuing their education. After due intervention, the children homes have been providing overnight protective stay to the CICLs, something which I had just said before. Then 3 CICLs in Guwahati district who were repeat offenders have been engaged. They have been put to productive work, and they are now engaged in drama and mask making through the help of an NGO named Replica. Their ICPs, their individual care plans have been prepared. Then SSA, Samagra Shiksha Abhijan has extended a Shiksha Kendra at Observation Home Boko. Then healthcare guidance and counseling is provided in our homes. Particularly, there are 7 HIV positive CICLs on how to maintain physical fitness, how to participate in group activities. Then this is our district child protection unit Golaghat, one child in conflict with law and who is a repeat offender. He got enrolled in a school, and after repeated counseling and guidance, he has now secured a government job in the last recruitment drive. Then CICLs of Observation Home Jorhat are engaged in gardening, carpentry, training, tailoring. In 2022-23, 30 CICLs were converted to CNCP by the JJBs of different districts. Total of 244 CICLs were referred for preliminary assessment, during the period of April 22 to June 23. And 10 CICLs whose parents refused to take them back. We, the community, we managed to, convince the guardians to take back these children into their custody. And till date, we have provided 38 children in conflict with law with preventive sponsorship under Mission Vatsalya. And these are some of the glimpses of our courts, child-friendly environment here. These are some pictures of sensitization programs. This is a picture of a child-friendly JJB. Then CICLs taking part in a drama workshop. Thank you very much on behalf of Assam.
Thank you so much, sir. Now that the state presentations are over, we will now have an open house discussion, which will be followed by observations by the chair. The technical sessions will start thereafter.
Yes, any queries from each of the states? If you want to ask any queries to either to Mizoram or to Nagaland or to Arunachal Pradesh.
I don't have a query exactly, but I would like to congratulate Arunachal Pradesh and Mizoram for rolling out the child helpline. We are rolling out on the 1st of September.
Good. That's creditable. Anything from Mizoram? Anything you like to add? Nagaland? Anything to add? Arunachal Pradesh? Assam, Mr. Majumdar, like to add anything? Any one of you? Any one of you? Please come forward and say anything. Please come and say. Doesn't matter. You come here and say. No problem.
Observation homes are in Assam, so they are already overloaded. So the petty offences should be disposed of at the early stage, sir. That's my request, so that we can, capacity of the observation home should be kept in a good position and all, sir. Thank you. And for preliminary assessment, sir, we need a guideline, proper guideline. Thank you.
With regard to guidelines of preliminary assessments, I want to inform the House, as per direction of the Supreme Court, the NCPCR has already formulated a guideline with regard to preliminary assessment. And another aspect, so far the expert is concerned, the National Institute of the Mental Health and Neurological Science, NIMHANS, they are doing a lot of research and has also formulated a format for the experts, how the assessment is to be made. So the expert can take help of that format, and also they have brought out a very long format questionnaires, how the assessment should be carried out by the expert. So these inputs are there already, so that things can be used for preliminary assessment. Thank you.
And Justice Ali, as you know that pan-India, this environment and we have in the Northeast, bus differences are there. So in the preliminary inquiry that matters, that's been taken with the help of the NIMHANS, whether these factors of the Northeast has been taken into consideration.
Basically, they have formulated the format on basically on the mental capacity assessment. This, is nothing for the different states. It's a common thing, human behavior, human psychology. So there may be some aspects, the region specific, that 90%, 99% are basically, common to all. So I think that will be very helpful for preliminary assessment
So-
for the court and board and also the expert in the field.
How is it available in the network, in the website?
Obviously, it will be available in the, let's say, the Government of India or NCPCR website. It may be available because we have got it.
Okay. Anyone?
And I would
Yes,
just
Mr.
add
Justice
to,
Surana?
I would just add one more thing. Supposing if for a particular state there is some requirement which is state specific, that has to be pointed out to the NCPCR, then only that can be incorporated in the document.
Okay.
Unless you point it out, maybe they will not be aware of the special requirements of any particular state.
Justice Bujarbura, you would like to add something?
Thank you.
Okay. Madam Khan?
Yes, a questionnaire was circulated to the districts regarding preliminary assessments, and we have given our feedbacks when I was in the district regarding how the assessment is to be made and how assessments are made.
So from the districts that was circulated, you have submitted.
Yes.
Whether it was done in the state of Mizoram, or you able to tell us? So in Assam, it was implemented. The circulation was made and they have submitted.
Sir, in reply to that, sir, I would like to state that the state of Arunachal Pradesh has not submitted any kind of specific issues that in fact, we have not even got a copy of the pro forma prepared by the NIMHANS. So we'll have a look at it after we go back.
Madam Khan, will you just explain elaborately how you got that?
Yes, we got it from the registry and we sent it back to the registry. That entire pro forma, we have filled it up and we have sent it back to the registry. It was in the year maybe 2022, 2021, maybe 2020.
Okay. Now you have heard that it was sent for all the district judges of the High Court, the district judges of the Assam. So registers from the Mizoram, Arunachal Pradesh and Nagaland, they are here. So we'll also like to see that they circulate these things to the respective districts so that they can submit their respective forms. Well, it's time to conclude. I'll just, with my own experience, I'll tell you one thing. Few years back, about 2-3 years back, I visited, along with my Register of Vigilance, Silchar district jail. There I found a professor of physics sentenced under section 302 for a murder. He was so deeply involved after committing that crime with the jail inmates. Under him, many jail inmates passed class 10 examination with first division, higher secondary in science with first division, and BSc with physics, mathematics and chemistry. Why I am saying it? Because he had given his involvement, he was so involved with these inmates, and he made these jail inmates to pass these exams successfully. Normally when a child is there in a child home or children home or a special home, we know the childs are more interested for the sports or for some activities, musical activities or something. Probably we should see that to bring them to the mainstream, we must calculate their habits, what they're interested, because I remembered few years back, a lady who was involved with juvenile issues told us in a meeting here that there was a person at that point of time, he used to play basketball. So he was in a home. Later, because of his activities in the sports, that lady was very much involved with that particular boy. And he represented the state. She was from Karnataka, I'm rightly remembered. And that's how, if we can bring this child, their involvement to the society will be more and they'll be away from all these activities. Now regarding we have seen what every state, this Nagaland, Mizoram, Arunachal Pradesh and Assam has given. But they have shown, they have placed their best. But at the same time, we also to verify our own weaknesses where we are lacking behind so that we can progress. For rehabilitation and restoration, there has to be some kind of budgetary provision for the implementation of the schemes under the Juvenile Justice Act and POCSO. Our state government, social welfare department. Yes, like to say something?
A similar person, a professor convict, I came across in Morrigaon jail also.
Good.
The district judge Morrigaon with me at that time.
Mr. Nayan is here.
He was also performing the same nature of work as suggested by Justice Patel.
Right.
So what thought is going on in my mind, if we can find out the intellectual convicts amongst the convicts,
right,
and we can, with their consent of course, we can evenly distribute them amongst the various jails, maybe all the jails can be benefited from their knowledge and their what
True.
they can contribute.
True. No, this was just I pointing out because there are persons who are working hard and deeply involved.
A particular person was there, he was also a professor, he is also a convict under 302, and he is doing the same work there. And he is in charge of a library, he is in charge of just bringing all other convicts to their, to increase their level and all.
Right.
So, thank you.
Why I am saying about budgetary provision? Social welfare department people are here, they will be aware. Earlier there was no such budgetary provisions for the state of Assam. And it was a few lady members of the parliament, Hema Malini, then Sri Devi, Jayaprada and all, they contributed certain amount from their fund for the state of Assam. We had a secretary at certain point of time who was involved in these juvenile matters, and for the first time in the state of Assam during the regime of Mr. Sonowal as the Chief Minister, some budgetary provisions were made for implementation of the schemes under the Juvenile Justice Act. So what I will request the concerned officers to impress upon the respective states so that special budgetary provisions are made for implementation of the schemes under the JJ Act as well as POCSO. And to find out, as Brother Justice Bujarbura has pointed out, these intellects to get their help so that these juveniles who are in the homes or in the institutes show that they can come to the mainstream easily. We have to find out the habit they have, or we can develop them with their own good habits. Thank you. It concludes this because next session to start. Thank you. Namaskar.
Thank you so much, Your Lordship. Welcome to the first technical session. The theme of this session is Child in Conflict with Law, Prevention and Early Intervention. This session will be chaired by Honorable Mr. Justice Asinto Molla Bujor Borua, Judge, Guwahati High Court. May I request His Lordship to kindly come to the dais. I now request the officials of State Child Protection Society, Department of Women and Child Development, to felicitate Honorable Mr. Justice Osinto Mollo Bujor Borua.
For this session, we also have with us Ms. Bharati Ali, co-founder, Hug Center for Child Rights, New Delhi. Ms. Bharati Ali will now be felicitated by the officers of the Guwahati High Court Registry. I would now like to request Honorable Mr. Justice Osinto Mollo Bujor Borua to give a brief introduction to this session.
A very good morning to all. These 4 minutes will be consumed in that only. The topic for the discussion, conflict in law, prevention and early intervention. The topic itself is in conflict. Why I say the topic is in conflict? Conflict in law under Section 2B of the JJ Act says, who is alleged or found to have committed an offense and not completed 18 years. So it's in past tense, committed an offense. And when we say prevention and early detention, prevention is something which has to be done before the offense had taken place. And early intervention, of course, we can mean that it was only in the preliminary stages of the person committing the offense. At that stage, some kind of intervention comes in. Now, when you speak of prevention and early intervention, prevention, of course, has to be, in future, we expect someone to commit an offense who will be underage. There has to be some kind of a mechanism for an early detection that a particular person is likely to commit an offense. And at that stage, the authorities makes an attempt to prevent that person from committing the likely offense. And early intervention, we can understand that the person committing the offense is at a very early stage of getting into the act of committing an offense. And once he is detected, some kind of mechanism can be involved to prevent him or to wean him away from committing an offense. Now, for early intervention, it will be a little easier because we know the person had already begun committing the offense. Difficulty will be prevention. Now, to involve in prevention, first we have to identify the juvenile who are likely to commit an offense. Who can it be? If we go to Fancy Bazaar around 9:30 or little later, when all shops and commercial establishments are closed down, you'll find a lot of small children moving around there. They're rag pickers or whatever activities they are involved. If you feel bad for them, you put down your window pane of your car, hand over a 10 rupees note, thinking that one is there. And by the time you complete the process of giving the 10 rupees note, another 10 will be near you. And if you intend to give 10 rupees to all the 10 who are near you, you'll find hundreds are there. No one knows from where they have come from, where they stay, what they do. You only notice them around that time. These vagabonds or the street urchins, we should take special care of them, because what actually they do, where they live, where they stay, because daytime no one notices them. Maybe some kind of prevention act can be done with this category of people by the specialist organizations. Next tool, what comes to my mind, the juveniles who are likely to come in contact with the hardened criminals. The category of people whom we can foresee that they are likely to come in contact with the hardened criminals. And we can take a preventive measure beforehand by trying to counsel this category of people that, please, don't visualize is, especially the children maybe from the higher societies, the higher families in the societies, but their family background may be a little disturbed. You don't know what kind of a state of mind these people can be. Maybe some work can be done in this category of people. For the early intervention, those casual offender, it won't be out of place, say, suppose a school children who is a regularly otherwise a very bright student, he may go to a shop and steal one small book or comic or something. A tendency develops. He's a casual offender. He's never connected or nor he has any criminal mind. This category of people, if anywhere they are identified, they can be counseled upon to convince them not to involve in such kind of acts. Other category may be the sexual offenders below the age of 19, especially one we find that it's mentioned by Justice Pathak also, those offenses which are said to be under consent. But ultimately it's an offense as long as the law remains as it is. This category of people can also be counseled so that they come out of their habits. Difficult will be the people connected with the hardened criminals. This is the most dangerous aspect for the society. A hardened criminal may like to commit an offense and he is set to trial, he'll be convicted. Nothing prevents the hardened criminal to identify an appropriate juvenile to commit the offense on his behalf. Suppose it's a 302 murder case. A juvenile is selected by a hardened criminal. Instead of doing it himself, he'll get it done through the juvenile, and the juvenile will get the benefit of the juvenile law. This is a serious situation for the society. Society must be vigilant enough to identify if any child is noticed to be in the vicinity of a hardened criminal or interacting with a hardened criminal. Maybe we can take some steps for intervention to prevent this child from getting more involved with the criminal. Fourth category will be the juveniles who are hardened criminals themselves. One extreme example I had given on the lower side, that is a casual offender, a school children stealing a comic book from a bookstore. The other extreme will be, we all remember the Nirbhaya case. The person who was the actual perpetrators and done the act in the most heinous manner was a juvenile. How do you deal with these kind of people? The law, of course, have been amended in the meantime after that to some extent. But maybe we can think of some ways, if we can, weed out these persons who belong to the category of hardened criminals also to come out of their habit and be an honorable member of society. I hand over to Ali.
Thank you so much, Your Lordship. Ms. Bharti Ali will now be sharing her thoughts on this session.
Thank you. Very, I think almost afternoon or closer to afternoon to everyone. I am really glad to be part of this consultation, and I thank the High Court of Assam as well as the state departments concerned for making this possible. Before I get into the presentation, I would just like to ask everyone that if you're not given food for a day or maybe 2 days, what would you do? You don't get food. Anyone, please feel free to respond. Beg, borrow, steal. Okay. You don't get food of your choice, your liking. Compromise. Not everyone seems to be very happy with the word compromise. Yeah, I mean, and I think this session on prevention is actually about some of the issues which are thought of as softer issues, but they're so basic that if we don't address them, we will actually be subjecting children to situations of greater harm, including coming in conflict with law. So, and I know, I mean, hunger can bring aggression, can bring anxiety. Malnourishment is a huge problem. If you're not addressing that, you're not addressing a lot of mental health issues that are also connected to undernutrition and malnutrition. So I just wanted everyone to think about that. Some data here, which is coming from the NCRB, and I would, even before I go into that data, I want to make a point about data mismatch, because the data that was presented today by the different states and what the NCRB is a huge data mismatch. And if we don't have data, then whether it's prevention or diversion or rehabilitation, nothing really can be planned well enough and then implemented well enough. So the data from Assam, of course, shows that children in conflict with law are illiterate. 48% have not studied beyond primary level. 7% have studied beyond class 10, of whom 0 are at higher secondary level. And if I look at similar data from other states that are present here, in Arunachal, 96% of CCLs have studied above primary but up to matric, that is class 10, and 4% who are above higher secondary. Nagaland, 29% up to primary and 71% up to class 10, between primary and class 10. Mizoram, 28% up to primary and 69% primary to class 10 and 3% higher secondary. The second important data set that NCRB gives you, and I'm talking about using data which is available in public domain, because a lot of data on children in conflict with law is actually not available in public domain, which is on family background of children. So as you can see, 75% are living with parents, 23% living with guardians, so they have someone really to look after, but only 2% are homeless in Assam. In Arunachal, 96% are living with parents, 4% with guardians, none are homeless. Nagaland, 71% with parents, 29% with guardians, none homeless. Mizoram, 82% with parents, 8% with guardians, 10% homeless. But the reason I'm giving this data is to tell us that, you know, there are some very clear areas that we need to work on and invest in. I talked about nutrition, and with nutrition, also early childhood care, which is when 90% of the brain actually develops. So the essential 0 to 6 years, you know, if we are not taking care of those 6 years, we are actually raising a generation with a lot of mental health issues, with a lot of deprivation, and which can lead to problems. The second area is education, as you saw. If you're not investing in education, and right to education is at the moment only up to the age of 14 years. So after 14, if parents have to make a choice between education and other needs, then they are likely to forgive and give up on education of their children. So maybe one of the things to look at and the possibilities to work on is how to make education accessible for all up to the age of 18 years. or through strategic partnerships if we can bring corporates into that field, but that's an important area. And the third area, as has been mentioning, you know, we have to look at preventing offending by children as well as reoffending. So both are equally important. And data here tells us, again, Assam, if you look at it, that about 11% cases are such where you know, the cases had to be quashed, or they unoccurred, or they had to be discharged by courts. And this 11% could certainly have been avoided. You know, why did these children have to come into the system at all, if at the end of the day the Juvenile Justice Board had to quash them? So the police will have to really brush up, and law enforcement agencies will have to really think about ensuring that they're not catching hold of cases of children unnecessarily, which actually end up in this manner. And this happens on day one. The law says when a child is produced, the JJB has to assess whether the cases has occurred, not occurred, and can you know, finish it off on day one of the production itself. So this can be avoided. And a common issue that's been coming out from various states is that you know, there are supposed to be 2 social workers in every special juvenile police unit. So structurally, we may have probably all the structures in place, but we may not have the required human resource. And these 2 social workers can play a very important role in talking to children, interviewing them. I saw a very nice thing written outside on one of the standees, which comes from the police, I assume, about respecting children and how to talk to them. With the officers on duty being constantly stressed, it only makes sense to have social workers in the SGPUs to have these conversations with children, and at that stage decide whether to proceed with any formal investigation, you know, or not. The other issue is about children held guilty. So if you look at data, again, NCRB, total number of inquiries or trials that were completed in 2021 were 140, of which 93 were held guilty. So the rate of conviction is 66%. Similarly, you know, the rate of conviction in most other states is between 60 to 66%. Some of the states that I noticed also have a 100% conviction rate. And those are also areas to look at. The other area with conviction rate to look at is pendency. So if there's large pendency, then you know, the likelihood of children losing faith in the system also increases. Likelihood of families losing faith in the system also increases. And if during pendency children are continuing to be in detention, then that makes things even worse. So the suggestion in the morning about petty offenses, I think, is a wonderful suggestion to look at. In Delhi, we, through a judgment from the Delhi High Court, we've now managed to ensure that petty offenses do not you know, linger on beyond 6 months as required in law. So after 6 months in petty offenses, the law terminate the proceedings, and that is a step being taken by all juvenile justice boards. I think that can be a good practice to look at. But I will caution again, juvenile justice system is not meant to say, okay, let children come and then let us leave them on advice or admonition, or for lack of being able to complete inquiries in time, let us terminate the proceedings. We have to also ensure that they don't keep coming back into the system. And therefore, even when we are terminating matters of petty offenses, the individual care plan has to be important. And we have to have enough people to be able to make those individual care plans so that we can prevent reoffending. The number of children deprived of liberty in Assam, you can see it's 30%. And it's close to the national average, but again, a concern, because deprivation of liberty has to be a measure of last resort. There are risk factors that bring children into conflict with law. There's a UNICEF report which I would suggest everyone should look at. It's an advocacy brief on child justice dated November 2022. There are individual factors which, like I said in the beginning, could be related to nutrition deficiency, could be related to other factors that affect a child. Then there are familial factors where there is violence in the family, and those will also have to be addressed. So we can't look at a child only in isolation. A child is part of the family, the community. There are decisions at the national level also that are affecting the child, and all of those will have to be considered. If there is displacement, we all want development. So it's not to say that there should be no development, but when there is displacement, can we also consider what children need and provide for that? So our thinking will have to go up to that extent, from nutrition to looking at some of these situations that are man-made and created situations, to natural calamities. Assam floods is a huge issue. So we'll have to look at this gamut of factors that actually put children to risk. And I was very happy to hear that some risk assessments and vulnerability mapping exercises have been initiated in some states. Then we have to have factors, which foster protection. And again, there has to be action at different levels, including action with peers as well as family, community and school. Do we have communities now? Mission Vatsalya says that 5% of the budget budget available with panchayats has to be spent on child rights. So that perhaps has to come into our action agenda. If we are not going to monitor where that 5% is going, it's definitely not bound to be getting used at all. But I don't see anyone probably here from the Panchayati Raj department. It has become an important department today because of this 5% of its budget which has to go to child rights. So those kind of protective factors will have to be built in, and we'll have to work around those. This is the basic pyramid for with respect to prevention. So primary general prevention programs for families and children. Somebody mentioned sponsorship in the morning. Now again, Mission Vatsalya has two components on sponsorship. There's preventive sponsorship as well as rehabilitative sponsorship. So if preventive sponsorship program can be rolled out in a big way, I think we will have addressed a lot of child vulnerability in a very positive manner. But sponsorship will also require follow-up and a task force which is willing to do follow-up, because we are aware, of how money can be used or misused, not really reach the child it is meant for. So therefore, that follow-up becomes very important. These are some of the international conventions that I've listed. I'm not going to read the entire matrix, but there is the UN guidelines on prevention of juvenile delinquency, known as the Riyadh Guidelines. Then the UN Committee on the Rights of the Child has a general comment number 24. Then there's the United Nations Common Approach to Justice for Children. There are model strategies and practical measures on elimination of violence against children, which is important for ensuring that children stay protected. And then the United Nations Congress on Crime Prevention and Criminal Justice has also developed certain guidelines. WHO talks about preventing youth violence. And there is a United Nations General Assembly resolution which specifically focuses on using sports and integrating sports into youth crime prevention. So, having said that, and I think between the JJ Act and Mission Vatsalya, if we can establish necessary coordination and convergence, a lot can be achieved. I'm skipping these because there are a lot of responsibilities which are laid down in Mission Vatsalya for different duty bearers, including SCPCS, DCPU, DM, and the village and ward level committees which are to be set up under the Panchayati Raj institutions. So the responsibilities are clearly laid down. I don't know how many of us have actually done the exercise of breaking them down to see who is to do what. Yes, I've already talked about this. I'm going to come to some practices which are taken up nationally. Sir referred to children in street situations. There is a CISS application in the Bal Swaraj portal of the National Commission for Protection of Child Rights. The idea is to identify such children who are on the streets for a large part of their day or night. Some of them may have families, some may not have families, but to identify them, track them, and monitor in school. Connected to this, there have been programs where people have invested in the education departments have invested in tracking children who remain absent from school for more than 2 or 3 days. And those are also interesting programs to look at and replicate in other states. With technology, it becomes easier, at least with respect to children in schools, to find out why they are not coming to school and then address it. There are programs by the police. I think Operation Smile and Muskan is often talked about in many forums. But this is the Yuva project of Delhi Police, where they've initiated an effort to connect, to provide vocational training to youth who are identified as youth at risk, and then also find them employment. So there is, it was being done under the PM, one of the schemes of the government, and now they've also roped in the corporate sector. So these are just innovative possibilities, where strategic partnerships can go a long way in changing lives of young people. Mental health interventions are really important. The only problem is that we, as a country, feel that everyone is a counselor. All of us are fantastic, superb, we can, counsel. But with children who are in conflict with law or who are in some of the most deprived situations, it's not just about counseling, they probably may require therapy. So there's no diagnosis of the mental health problem, and we think counseling will resolve everything. We need to invest in both diagnosis and therapy. How are we going to do that? Some basic first aid counseling is an area to look at and invest in, but we definitely have to, build a task force of therapists as such. And I know in Assam there has been investment in child rights courses. For example, in the Tezpur University, there is a course, and the idea was to get, the workforce from amongst students who pursue such courses. Similarly, for mental health, we'll have to make those kind of investments so that we can get therapists. This is a short film. I don't know if we have time, sir. Then we will play it. Otherwise, you can watch it on YouTube. Sir, with your permission, can we play this? It will take it will take some time. Otherwise, it could be watched on YouTube. This is to do with sports. I don't think it's working here. I don't see the.
You can watch it over to YouTube if you give the link.
So the link is there. The link is there, and it can be watched over YouTube. The reason why I wanted to show this film was because drugs has come up as a huge issue. And often when we look at the demand and the supply side, but for the supply side, we definitely look up to the law enforcement agencies to be able to deal with that aspect. On the demand side, a lot of demand for drugs is because of various reasons that many of us understand, which lie in family and community, but then also complete despair and loss of hope amongst the youth. Sports has been very successful in connecting them to physical activity, taking their minds away from, issues that raise anxiety and bring depression, and channelizing it in a very positive direction. So this video is about a club where children have been participating in rugby. Now some of them are playing national level. As this experiment was also tried in Delhi in one of the observation homes, the only problem was that the observation home said that we can't allow. The agency that was running this, some of you would know, they said that, if these children are doing so well and can play national level, but if you're not allowed to take them out, then we won't get sponsors to invest in a program like this. So we'll have to probably think of ways of, investing in these kind of programs, and also seeing how children in conflict with law, even if they are in observation homes or wherever, in institutional care, can be given this opportunity to go out and play and represent their district, their state, their country, whatever they are capable of. The same goes with education, because these are children often who are not really able to even pursue their education because they are inside these institutions. So that is why I wanted to show this. But the questions before us are about how to make this, how to have a national child connected to a national prevention strategy. We can start at our local levels, but we'll have to plan out the key result areas. What are those indicators that we want to look at? What is the MIS that we want to develop? Because if you're not developing an MIS, if you're not identifying the key result areas, then there are so many good things we can say in consultations and go back, and then nothing really may come out. So if you could spend some time thinking on those lines, I'll end with that request. Thank you so much.
Thank you, Ms. Ali.
Thank you so much, ma'am. It is now time for the open house discussion, which will be followed by observations of the chair.
Yes, Mr. Kier,
Thank you, Justice Bujar Barua, and thank you, Bharti, for the presentation. Well, I think I'll just make a minute of observations from the presentation, because I have extensively worked across communities, and especially the children that you talked about in Fancy Bazaar are from railway line number 2 and 3. They go and stay there. We try to run a program there, but interestingly, our program was completely demolished by the railways. Now, that is the problem with children who are...
Sorry, it was demolished by the railways?
Yes, because they are all illegal settlements. Now, that is the major problem in Guwahati city, which has extensive informal settlements that are not recognized. And the children, even if an NGO like ours, who have been trying to run programs, or other organizations, we share the same concern. You start to run a program, you get the children out of labor, you put them back into school, the next day their houses are demolished. So what happens? They go back into vulnerability. So it's a vicious cycle. So these are very structural, fundamental things, that you are landless. You are staying in a city because you have, flood situations, displacement, conflict in your villages. You can't afford, the rental housing in Guwahati is very steep, so you go into these empty government lands. But that also is illegal. So this entire navigation, which is what is right and your kind of, rights, children get stuck. And because of being forced to live in that vulnerability, many children fall into the vicious trap of the crime. Then institutionalization, second point, is always called as the last resort. But if you look across the successful programs with children who came in conflict with law is with institutions. Because it is not humanly possible. Guwahati itself would have, I think, more than 50,000 children living across slum areas and adjoining places. So it is not possible to run programs everywhere, So only children who are doing good or who are not going into recidivism is being rehabilitated are through little institutions that are running. So that is one thing which I wanted to say. Counseling, which Bharti said, counseling and therapy is such an upper class concept, let me tell you, because where will you get a good counselor? It is impossible. My therapist charges 2,000 rupees per session, I am doing excellent. But for a child who's getting a counselor who is being paid 8,000 rupees, 10,000 rupees, you will never get high quality counseling. So I think that investment into personnel is, sarkari hua to it has to be like, 10,000, 8,000 rupees, not more than that. Child protection, even lesser. Then universities. If you look at the universities around, many universities are not giving out excellent counseling courses. I had some teacher from one university come and interact with me. That person had no idea about therapy. That person did not herself know how to do assessments. So in the name of counseling, now with children in conflict with law, they are massive problems. Children have neurodivergent issues. They suffer from ADHD. For that, an MSW in counseling cannot help. But if you look at our system, many of them are MSW counseling dealing with such serious issues which they're not capable of dealing with. So these has to be looked into. Maybe some of the, in positive side, Assam, we very naturally veer towards clubs. Youth clubs are very popular in Assam societies. So probably if, these kind of local clubs can be formed from a prevention perspective, where it can also be a hub for children to have a good time, one, because children need to have good time, which they do not, because even schools don't have playgrounds nowadays, many of the government schools as well. So, one, to have a good time, which can be used as a diversifying mechanism, because what happened in adolescence, we have seen that, you're biologically changing. So, a huge catharsis is sports. We need that. Music, sports, theatre. But to make it accessible in the community, at the community level is something which probably can be thought about, and organizations are willing to, or if the government takes an initiative or makes an investment, probably we can, to some extent, reduce, crimes committed by children, or the problem of recidivism. So I think with this, I have a lot more, but I'll let others speak. Thank you so much. That is
Anybody? Any views to express on this issue?
Yeah, I'll just come in, I think.
Yes, please. Yes, please.
Thank you so much. I come from conflict zone area. Now it is almost like a post-conflict area, Kokrazar Bodoland Territorial Council. I think I totally agree with my friend. See, what happened is that there was a ICPS program we have. Under that ICPS, Children Club, Adolescents Club, Community Child Protection Committee has to be established and empowered in the community as a safety net. I think this is the prevention level which we could able to expertise. And this has to be club with the community sports club already established in the villages. So if this space being created, I see lots of possibility of engagement of the adolescent in such activities. So now I come back at a second point. Second point is very disturbing. The recently 13 girls was raped by the juvenile, 4 of them. The case is referred, I think, to Boko Observation Home. Now, as a community practitioner, what is the step we should able to take? Because for us, it is a crime. It is a heinous crime. And under such circumstances, what is the corrective measure? But most of the corrective measures, what we see is that they are out from the observation home. The process has to be in this way, as per the Act. They should be in the observation home till the age of 21, then transfer the case into the jail. But I think that's not happening at all. But under such circumstances, because it is a heinous crime, what action need to be taken in terms of correcting, whether they should be free, go back home, without any preventive measure activities further in the community. This is where I think our intervention has to be. And I often wonder, during the COVID lockdown system, there was no street children. Entire lockdown system, there was no street children available in the street. Where have they gone? There was no analysis on that from any of the sections. Then when the lockdown is closed and the normal life came back, children are back on the street. And during this lockdown period, where have these children gone? I think these are the areas, I think we are not able to map out our vulnerability area and able to focus the preventive measure activities in the community. I see lots of possibility. I work very closely with the children of the forest dwellers community, who are exclusively socially excluded community, no doubt. After the conflict, they are displaced. They are being living into the forest area without basic amenities. Those are the vulnerability area. We see lots of children being trafficked, taken away, lured for the different purposes outside community. And I think if a state as a whole, if we could identify certain hotspot area, and we start working on that, maybe the initiative has to be taken. Therefore, I think adequate investment has to be required for that. Yeah.
So to conclude the session, one of the reasons what we, as said by Madam Bharti, hunger. Hunger may be a good cause. Other is illiteracy. But what is going on in my mind, that in Assam we are having free education, Mr. Mojumdar. Midday meals are served. But possibly children are still out who are not into this education system. So maybe we have to look for a bridge to narrow this gap so that almost all children come within the fold of the education system, where possibly to a great extent by the concept of midday meal, even the hunger will be taken care of. Two, what Miguel had said, that that railway eviction, and what you have said, that during the lockdown the children were not visible. So this possibly gives an impression that these children are placed by some agency, some authority somewhere. Otherwise, during the lockdown, why they will disappear? If they are children in the manner that they are staying somewhere, like the railway land you were saying, and they come to the fancy bazaar time in the night time for doing their work, they ought to have been there in the lockdown time also, or they have to been around somewhere, if not in the fancy bazaar area. If they are not there, means they must have been regulated by some agency, somebody somewhere. Maybe if we can try and identify these agencies and strike at the root, maybe we can take care of the problem. And once this problem is taken care of, maybe the system can take care of these children. We can adopt the guardianship of the children, the state can adopt it. And regarding this eviction issue, that what Miguel has said, that although efforts were made to bring these children back to track in the society, and when the process was on, there's an eviction. And now we don't know where they have gone. Maybe the government of Assam can also take up with the railway authorities, because they are also having some schemes of their own. That if you do the eviction, do it. You have done it for the good. But if the children are there, bringing back to the society is affected because of this eviction, maybe the railways can all provide some alternative to this. And what I feel that we need a well-coordinated approach between the organizations working at the ground level, what Mr. Miguel is saying, the organizations which are providing the relief, like CISS, Bal Swaraj portal, what Madam Bharti had said, but possibly there's a lack of coordination, so that the persons who are to be benefited of these schemes and facilities being available, they are not reaching the system, what I mean to say. I'm not saying the system is not reaching. The people who are to get the benefit, they are not reaching the system. So maybe we can think of some mechanism, some well-coordinated approach through all the stakeholders, through all the persons involved in this. And maybe we can have a better result. And thank you. If any further question from anybody? Sure, definitely. Yeah, definitely. Try this one.
There's someone who's raised.
Dr. Oli Goswami from the Department of Forensic Medicine, GMCH. And at the beginning, I'd like to say that my knowledge regarding law is strictly limited to the work I do in my department. And just to raise a few points that I find daily in my department. Number one is the elopement cases, the huge number of elopement cases that come, and the girls are 16 years, the boys are 17 years, or the girls are 13 years, boys are 15 years, and they are booked under POCSO. So what can be done regarding that, sir? Can something be done? Because again, we are actually creating new CICs, if I am not mistaken, because these things are certain things which can actually be avoided putting a adopted boy. And again, that comes under POCSO. So I think we are creating more and more accused ourselves. If something can be done for amicable solution regarding this problem, a lot of problems can be solved. Maybe we can lessen the loads on those homes. And secondly, sir, for the education that is imparted in the school, the sex education imparted to the school nowadays, it is not that it reaches the right, in the right way. The children should understand, because I have got cases not only from the less affluent schools or the less affluent classes, there are from very, very affluent schools in Guwahati, but a class 11 girl comes and tells me that sexual activities after the age of 16.
Doctor, you can understand the issue we are trying to raise.
Yes, sir. So maybe, sir, that...
Maybe intervention. Maybe you can try to counsel those people, you can try to bring awareness among this category of people so that they win away from this kind of activities. But within the existing frame of law, as long as it remains, it has to be looked possibly what is provided in the law. Yes, anybody else? You want to say? Because you're almost running out of time.
Thank you so much for giving that last opportunity as well. I just wanted to share that the case of the boy in the Nirbhaya case, since I was personally involved with that case, I can tell you, and there is the judgment of the JJP should also be read. Judgments. So we've gone that far instead of, redacting names. But in that case, Justice Anup Bhambani at that time was representing the boy. He's now, when his house to get the Wakalatnama signed, the condition of the family was so appalling. And then we came to know what is it that led this boy to start working at such an early age and come in contact with people he should not have been in contact with at all. So that's where we talk about prevention. And the other thing I wanted to share is the Tihar jail, and Justice Geeta Mittal wants family and see what is the situation. Again, when I went to that family, the wife was on the verge of taking to prostitution. The children, everyone in the neighborhood was calling them names. Whenever they went out to buy something from the nearby shop or something, they would call him Falane ka bita, thief's son and so son and all that. I mean, it became very at these children again coming in conflict with law very soon in their life. It would just continue. So when we're talking of prevention, that's all I wanted to say. Thank you so much.
And regarding judgments not being made available, Justice Ram, do you think so? Because judgments are public documents. Anybody can apply for certified copy from any judgment of any court.
Sir, not with respect to cases under the POCSO Act and the Juvenile Justice Act. In fact, even lawyers were representing...
Some restrictions are there.
What I'm informed is that we only are required to mask the names.
Only the mask, but judgment
they are there.
Only the identity is protected, I believe, not the judgments.
Right, so we had filed an RTI and the response received...
Only that is limited. Names, definitely it has to be limited.
Madam, I don't know about
but
the
judgment as such are not limited.
I don't know about the practice in Delhi, but in Guwahati and the High Court jurisdiction, what we do is that these judgments are online and only the names are masked, so that it is very difficult to identify that the victim. But that is as per the Supreme Court directions we are doing.
And Guwahati High Court judgments, the moment it is online, anybody can have access over the website.
Yes, sir. We've done a study on cases under the POCSO Act from Assam, Delhi and Haryana. So we were able to find a lot more judgments in Assam compared to Haryana and Delhi. But with respect to children in conflict with law, I am aware that even lawyers have problems who are representing child copy. They are often denied on the grounds that we have to protect the privacy and confidentiality of the child. And
if it is okay, looked into, I don't think it is so. Okay.
Thank you so much. Thank you so much.
It is now time for technical session 2. The theme of this session is Principles of Diversion with emphasis on non-custodial alternatives, and it will be chaired by Honorable Mr. Justice Kalyan Rai Surana. His Lordship is requested to kindly come to the dais. We also have with us on the dais for this session Dr. Anand Kumar Asthana, child rights lawyer, New Delhi. Dr. Asthana will now be felicitated by the officials of the State Child Protection Society, Department of Women and Child Development. I would now like to request Honorable Mr. Justice Kalyan Rai Surana to give a brief introduction to this session.
When I see this topic of non-custodial alternatives, I'm reminded of the very old movie, Do Aankhein Bara Haath. That was a beautiful movie where alternative custody of the prisoners was given. And this is a concept which is again now picking up. But the issues which was flagged earlier about the children in conflict with law to be taken elsewhere for growth of their talent, like sports, other activities, these are still to be given a thrust so that we actually see the benefit of non-custodial alternatives. Because a child who is in conflict with law and is institutionalized, ultimately somebody has to take a responsibility that the child in conflict returns back. So therefore, the easiest task is to prevent their going out for their sports activities, for their other talent activities. There is another aspect which is related to funding of these alternatives. If you have skill development programs where these children in conflict with law can be sent, again two issues arise. Number one, whether a child in conflict with law, because of their minority, can they be put to asked to do some labor work? You are giving them skill education, they have to do something. Then again, whether this is in conflict with the other law that we prevent child labor, or we are encouraging child labor rather. So therefore, we as a country, we have to take a decision. If we are to give skill development to the child in conflict with law, then those activities of the state should not be read or constitute to be against anti-child labor programs. Because if it's not only the sports, you see in many countries in the world, you are just given a formal education up to a particular level. After that, there is a child assessment made, and then they are sent to other activities, maybe plumbing, maybe carpentry, maybe this forging of the forging industries. So all these are some maybe. So it's not always just like the education program in India, where we have to have the graduation. Some countries do not follow that traditional system, and then they pick up child as per their talent and then give formal educations in those aspects. Therefore, it's a time to think whether under non-custodial alternatives, we can have more emphasis on the alternative education programs so that these children who are now in conflict with law may develop their skills and be a professional in their field. So with this, I request Mr. Anantkumar Asthana to take over.
Thank you so much, Your Lordship. Dr. Anantkumar Asthana is now requested to deliver his address.
Chairperson of my panel, Justice Surana, has assigned me a duty to speak about two concepts. One of them, my Lord has briefly explored, alternatives to detention. And I suppose diversion is left to me, right? My dream is to become a doctor, but I'm yet not a doctor. Hopefully sometime. I practice in Delhi High Court on children-related matters. And I'm glad that Madam mentioned about this movie, Do Aankhein Bara Haath. It's a Vishantaram film of a very legendary era of 1960s, when the cinema used to be very socially conscious. And why I'm starting from mention which my Lord made about the film, there's a lot of juvenile delinquency which we are facing is a product of the cinema. If you look around, what is shaping youth behavior these days, not just the movies and films, but also lots of reels and YouTubes, and the kids are trying to emulate those patterns which they feel are very glamorized. Concern which is coming up here, juvenile delinquency and the children, and that will require various segments to play a role. Education, for example, the school system, health systems. Child protection system alone is not sufficient. This recognition we must have. This recognition we must have. Miguel mentioned about demolition. I know several stories of various initiatives made easily available, and there are a large number of kids around railway stations. So any good spirited person will be allowed by the railway authorities, RPF, to do your activity. But the moment that activity moves towards permanence, so several incidents like that happen. What has to be done is that the railway must engage. If there are children on the platforms and the tracks, something needs to be done by the department which owns those platforms. In 2012, there was a case which came up before Delhi High Court, where a minor child who used to do garbage collection from the train met with an accident and lost his legs. That case came up before Delhi High Court, and the Delhi High Court actually started up with the responsibility of the railways. Conventionally, it would have been for the WCD department to answer, because it will conventionally fall under Juvenile Justice Act. But in that judgment, the Honorable High Court actually made the railways as the primary respondent, and they fixed their accountability and asked the railway platforms to have dedicated places which could be used as centers for providing care to children who legally or illegally are present. So this was a little diversion from my topic. I'll come back to diversion. Diversion as a journal language indicates what it means, divert. But divert from where? And it's not an activity which we have to actually design today or after this conference. It's an approach. We have to identify and appreciate this approach. And then you will read the law and you will find that legal framework is there. It's just why we need diversion. Divergence is an international law principle which recognizes the limitations of former judicial systems, right? All of us sitting here either are from judiciary or police or government, but we ourselves would like to engage with the judicial process. To the extent we will try to avoid it. It's only when it becomes unavoidable that we will engage with judicial process. Why? Because it creates hardship in our lives. Our tendency is to avoid any kind of conflict. This recognition is at the root of the international principle called diversion. From there we have to divert. So I'll just try to bring into your attention what we exactly have to think about. We have a law which says anybody below the age of 18 years requires a different approach. Now the right question to ask is, are all the children being brought under the JJ Act? That is the question we have to ask. Do we know of people who are minors and not in the juvenile justice system? Yes, we do. They are in the prisons. Their status is not of minor because their age is contested, right? Large number of, so if you see the JJ Act 2015, section 83M was inserted and a power was given to juvenile board. Go to jail, inspect the jail, see if there is any minor. Why it was done? Because somewhere there was a gap, at whose level I don't know, but a person who is a minor and should not be in jail is in jail. That's why the law says have this power and go to jail and find out. Diversion from jail, 1 degree of diversion. Go there, identify and look at the power which the JJB has. Take immediate measures to transfer them. I hope the learned principal magistrates and the social worker members of the JJBs have taken note of this power, but that is precisely diverging. For me, the most concerning, because with whatever limitation our juvenile justice system is working, is better the experiences children will have in jail. Me and Bharti Ali both were inducted into a committee whose primary concern was the pathetic situation in observation homes. There were repeated escapes happening. Every now and then you will have violence in the institutions. So some people said we have to make some law. We have to teach some lesson to these boys. That's how this started, and a committee was set up. And the committee was mandated to draft rules, discipline rules. Interesting. Maintenance of discipline rules in observation homes. And the context I told you, repeated escape. But when we set up, there were 2 principal magistrates part of it. 2 of us were, there was a director of the Department of Women and Child Development, 5, 6 of us. When we started exploring, we found out that violence in the institutions is coming from a malpractice. All these boys who are at the root of every violence have come from jail. All of them. They spend some time into jail, and then after some time when they are to get minor, they come to observation homes. And we made a recommendation that this cycle has to be broken. Otherwise our observation homes will never be in peace, because these boys are brutalized at the first place. Right? We wrote a recommendation to Commissioner of Police. Commissioner of Police wrote to all the police officials who do investigation, please be careful when you do the age investigation. After some year, when it did not yield any results, the matter reached before Delhi High Court of Judicial side, and that's how writ petition civil 888-9 of 2011 came, which gave comprehensive guidelines for elimination of incarceration of children into adults. I'm particularly talking about it because removing minors from prison is at the core of the juvenile justice system and also at the core of the judiciary's engagement with juvenile justice system. Initial engagement of the Honorable Supreme Court were on the issue of why there are children into prisons. That's priority number 1. Now, Juvenile Justice Act has given us mechanism in terms of section 83M. There will be challenges in rolling it out. One way of rolling it out is that we provide a written, carefully thought procedure. Where do we provide procedure? For implementing a provision of an act in the rules. Do we have rules? 4 states are here. I know Mizoram has rules, its own state rules. Mizoram Juvenile Justice Care and Protection of Children Rules 2019, and Arunachal Pradesh has its rules. I'm not aware about whether Assam has its rules and whether, I know that in Assam there is a rule drafting committee, that I know. That I'm aware that there is a rule drafting committee and there is a process going on, but it must be stuck somewhere. The rule opportunity situation we have in our state and provide a functional response to so many problems we have. Now, second, after we come from jail, diversion from observation homes. Is it necessary that we send all children to institutions? Is it necessary that we start a judicial proceeding in each and every case? So if you look at the legal framework, the juvenile boards have extraordinary powers to close the case on the first date under Rule 10.1.1 of the Model Juvenile Justice Rule. Merely on satisfaction, based on the perusal of the documents produced on the first date, the case appears to be unfounded or case is very petty, not requiring any rehabilitative, reformative measures, close the case. That's Diversion, Rule 10.1.1. It requires courage to write orders because there are no precedents. You will not find many precedents, at least in this part. But generally, it will require training. How do we build an environment, an ecosystem for rolling out diversion? Today, the limited time which we have won't permit me to take you through the entire legal framework. But I will definitely request you to read this Act and the rules. And the Honorable Chief Justice asked from the dais, raise hands who has read the entire JJ Act, the entire JJ rules. 5-6 people could actually muster courage to say that I have. And I understood why he asked that, because we don't get time actually to look into the details. We're so busy with our work, but I will actually request that find time to actually peruse those rules. You'll be surprised to see how much effort rule makers have made for providing you the solutions. Diversion we are talking about, but if you look at the rules and the Act, at least 20-30 provisions you will find in the Act and the rules which allow you to implement the philosophy of diversion. A police official is not filing final report for a very long time. Will you allow the child to, after this much of time? Under Rule 10.5, in petty and serious offences, if the police is not giving you final report, JGB is not bound to wait for it. Close the case, give the information to the IO, sir, your case has been closed. And a good public prosecutor, and I've seen it, a good public prosecutor will make an entry. An entry will go to the senior police official. Case got closed because the delay was made by IO. Automatically accountability comes in. The cases, the investigative priority goes up. Several provisions. Delay by JJB. Suppose if I'm a JJB and I'm not able to conclude the case within a time, then the chief judicial magistrates have a role. No case can proceed after 6 months without written permission from chief judicial magistrate. There is a law. Either you close it or you have to tell it to CJM. It's only when CJM will permit you that the case will move forward. Now that provision will create system accountability for the JJBs. I request you to have this time sometime. I'll also request Judicial Academy here to consider if any exclusive program for our officers, not just judicial officers, but also the police officers, particularly those who investigate offences, they could be brought together at some point of time for a dedicated full-day session only on exploring the Diversion Mechanisms Act. Because today is not a good opportunity for a very lengthy discussion. The concern which we have is why Honorable Supreme Court has listed these 5 areas for a national consultation. In September, I suppose there will be a national consultation where Honorable Supreme Court will look at these 5 themes. Diversion and the non-custodial alternatives has been listed in 5 top priorities. If you see the document which has been sent by Honorable Supreme Court to the High Court, these 5 themes have been put by the Juvenile Justice Committee for Honorable Supreme Court because these are important. The Juvenile Justice Committees were created in 2006 when it was found that the Juvenile Justice Act is orphan. Nobody really paying attention towards its implementation. It remained the only legislation which was adopted by the judiciary or the administrative side. And that's how the 2006 Juvenile Justice Committee started up. Towards the end, POCSO Act also got included. So now we have the Juvenile Justice and POCSO. These 2 acts are administratively monitored by the higher judiciary, and there's a reason why. I'll conclude by saying that the biggest challenge in rolling out any program on juvenile justice, particularly on children in conflict with law, is the stigma and contempt. Now, it's a very good law, but I will not be able to implement if I really hate this law. Right? And yet, what is I have done? I will put a question here that this is arrogance. This is not arrogance. If anybody has that view that the child is standing there alone is responsible and I am not, then there's a high misplaced arrogance because each one of us, collectively and individually, are responsible if there is any child conflict with law. So our approach cannot afford arrogance in our thinking. And we also do not have any escape from reality. If we have children who are into drugs, who are deleted, who do not have responsible health protection, then the consequences are bound to come back on us. There is no escape from that. So actually we don't have scope for not implementing the act. We have to implement it. So I'll conclude by saying that by the collective wisdom which we have here, honorable judges are here who are ready to give guidance, judicial officers are here who are highly sensitive and trained, we have police officers, we have government department officers who are ready to put their brain out of effort. If all of us come together and work towards building an ecosystem, an environment where these projects will be implemented. Now, how will that be done? It's not happening in one day. But we can definitely make a beginning through a sustained endeavors. I'm thankful Honorable High Court for giving me the opportunity to have interaction with you. I conclude here and then I'll request my daughter to allow me to come back there and have a discussion from there. Thank you.
Thank you so much, sir. We will now have the open house discussion with subsequent observations by the chair.
Yes, the questions or suggestions from the house. Anyone?
Should I just?
Yes, yes.
Yeah. Thank you, Justice Surana. Thank you, Anand. I think I will be just talking and can also raise with the Honorable Chief Secretary at some point, not the present one only, but also previous Honorable Chief Secretaries, about the juvenile justice model, the rules, state rules, which have been in a shell for almost, I think, 6-7 years now. It's a long time. So I think it is time that, and there include provisions for diversion, preliminary assessment, whatever is required. So the juvenile justice rules need to be implemented in Assam as well. I think some states already have the juvenile justice rules, but Assam has not. So I would request to this forum that the juvenile justice rule may be soon modified.
Yes, sir. Yes, sir. Okay. Please use your mic.
So, Lordship, I just asking. A juvenile does not appear respecting the notice or summons by whatever name they say and not past. Now, this court law, the juvenile justice court, is all about the magistrates. We are concerned with the rights of the victim as well as his child who is in conflict with law. Now, if there is absolute power, in no circumstances, no court's action will be taken. Now, leave it to the House to decide how the courts will ensure attendance and give justice to the victim who has suffered infraction of rights.
Sir, as far as 2016 rules are concerned, we had
Happy was that we drafted rules. They go to various departments. The process department went to Agriculture department, went to UNICEF department. But those feedback from those departments never came and could never actually go to the department for notifying it. But this year we have drafted up the rules based on the federal rules, and it is very much submission to ensure that every department is given 30 days time to get back. And if they don't give their feedback, we will assume that whatever we have written is fine. So we will be applying the rules within the next 3 months.
Sir, I can respond to the concern which sir has raised. Sir, may I have an introduction, please? Yes, sir.
My name is Dr. Ministry of the district of Assam. The district is Khanapara.
Right. So, if a minor has been granted bail, it's a technical question, but it's a minor has been answered. So, minor has been granted bail, and the minor just disappears. What do I do? What do I do with the case? What happens to the reformation? It's a loaded question because earlier there was a practice which was designed as per criminal law. In criminal law, also the people escape from criminal cases at max. Criminal law allows a person to be declared as proclaimed offender. How many proclaimed offenders we have? Thousands of them. They are not migrated to mass. They are there. But somehow our system can't locate them. So the question is saying about the people who impaired the process of law. There is a limit to which that person can be addressed. I was just looking at the new regime of the laws which have been proposed by the government of India. There is special consideration has been given on this, allowing courts to proceed further. In the Juvenile Justice Act, our job is actually similar. Simply in the sense that we are rehabilitation and reformation of the person who has run away from me. A person whom I have to provide care is running away from my care. Now the question comes back to me, why the person is running away from me? If I have benefit from you, I will just take close to my benefit from you. It's only when I am scared of him and I know the greater damage is going to come. So the question is I asked, and the reason that I asked you, this is a very important question. It's a question on the intent of the entire legislation. Somehow the terminology, the homes, the inquiry, these concepts are very beautiful concepts, but somehow our target of making these concepts meaningful for a person is still not met. Observation home, children will not run away if they feel that they are at home. In juvenile boards, I tell you, sir, and you will get your response. So from that, I was a legal lawyer for several years, and out of my own curiosity, I sat down one day and did my own study. Why I have minors coming from this particular area of Delhi in great numbers. So I looked at the addresses, made a list of all the cases, and I figured out on 2 locations that most of my cases are coming from these 2 areas. And then I sent 2 of my interns to go and visit that area. These were law students, 2 boys. They went and then they came back horrified in the evening and they said, please sir, don't send anybody there again. I said, why? Then they gave me the description. That place was a place where all kind of prohibited things were easily available. And that prompted me to go. So I requested a judicial officer from the legal service authority, and myself we went and visited the area. And the moment the families got to know that there is a judicial officer and a lawyer visiting that area, they came in great numbers. Mothers came and they said, sir, our lives are destroyed. They are so poor that we can't even leave this place. Drug is everywhere. Our children their lives have been destroyed. People are selling drugs here. Everybody is helpless. How do we do that? Then due to the effort, it took few years, we managed to get a drug addiction center opened. And sir, I tell you, the same families which were running away from JJBs, they started coming back in great numbers, requesting us to take our children, grabbing them, because they suddenly saw hope that my child can actually now get admitted in this drug addiction center. So I will say that children running away from our system and the families not having faith in our delivery is a challenge for us. If we could make our system meaningful for the people we have to serve, they will not go away from us. And even if they go away, I believe the number will be very small.
Sir,
That's how I will respond to you.
Yes, Brother.
Just the question posed by Roshan, possibly answered maybe in section 26 of the Juvenile Justice Act, which is any police officer may take charge of a child. So even if there may be an absolute bar in the rules for issuing warrant, but 26 starts with notwithstanding anything contrary containing any other law which also includes the rules. Maybe.
Even that, and section 10 also, permits apprehension of a child alleged to be in conflict with law. Therefore, they can be still apprehended and brought. The powers are there. But there is a prohibited order not to issue warrant of arrest that I'm not aware.
In the last rule, in the last rule in Assam.
Act will prevail over the rules. And the act says notwithstanding anything contrary to any other law.
We should start up the, juvenile, they call it, CICL, and to produce before the board. And board will pass appropriate order. Suppose he's in capable person in the institution, whatever they be. When it is produced, if it is found that it is not fit to keep in that proper charge, the board will take appropriate decisions. So it's not the warrant is not used. Police can be directed to take charge of it. So that the provisions can be taken.
Thank you, Roshan. Thank you.
I think we'll have to close it because the prosecutor otherwise will default in the other programs. So I know that yes.
When Kanaji was talking about the diversion, so what we understood is the diversion is very much under the act itself, which can be used for the betterment and for the good for our children who are in conflict with law. But our experience shows is that what Kanaji has already told, we need to show some courage to implement those diversions so that we can give the maximum benefit to the children. But the social worker and the JCB, the Consultation of the Construction of the JCB, not the principal magistrate and the two social worker. So this is a question, but this is also a reflection of what Sir has already told us. The particular capacity building and the particular knowledge on the particular subject is very much actually important, and we really need to take care of it because every case varies. We have gone through so many of jails where we found the both minors in those jails and all, but it took a long time to bring them out and do all those things. And what we found was that the courage was not present. But to take a decision on spot was something a problematic area at that time. And the thing is that if we see the continuous training, capacity building, and then the exchange programs, if one JDP is doing something great, then some other JDPs can learn from them. Those things are also need to be established from implementation point of view.
It's a very good suggestion. In one state, actually, there is a group. It's called Solution Desk, and it was devised by the principal magistrates themselves. They came for training in the Judicial Academy, and then in the evening they sat together, and then they shared their WhatsApp numbers. I used to be part of that, but I opted to move out from that group.
There also now we that the website has been launched. There also reportings are being made. Now we have to know that there is one kind of conflict in rebel jail, and it is reported. Definitely specific because we are in 2 days. One on the side, also on the judicial side. If somebody does like the members of the appropriate party, it's not the case where the JJ has been informed that there is a child in the jail and still no such detail. So only but the question is that impression very JJ.
My point also that like not only in the jail, other than also the other diversions, like cases can be there are so many cases which can be probably only gone to the on the first jail, and then but that also the board, it's a lesson and the social social workers. They need to be correct, and at the same time they need to have a particular all knowledge about it. Maybe they do this and nothing cannot.
That's why you have to do that. This is why we are doing this consultation. You see, we have not robotics or robots where everybody will do a work in a particular fashion. I'm still doing it, but that's why. And then because everybody can't act in an individual setup. It's not a formula where A plus B can be made multiplied by 2 and Z A B square. I'm sorry, I'm wrong. But the fact that when you understand when we realize that you are doing good practice, they will do it nice clear. So with this, I think that was quality time. Otherwise, we'll be improving time on the other sessions. So I'm thankful to Mr. Sana for his insight, since he has a lot of experience in dealing with these issues, and he's a very much 40 on the point. I'm thankful that he has been to be here and praise us all. Thank you so much.
Technical session will now begin on the theme right to fair trial, focus on child friendly procedures. For this session, we have as on the dais Honorable Mr. Justice Rajeshri Bhargava, Judge, Khanapara High Court, and Honorable Mr. Justice Manish Chaudhary, Judge, Guwahati High Court. May I request Justice to come to the dais. Honorable Mr. Justice Rajeshri Bhargava will now be presented by officers of the High Court Registry.
I would now like to request the officials of the State Child Protection Society, Department of Women and Child Development, Assam, to please take Honorable Mr. Justice Manish Chaudhary, who is also requested to chair this session. Honorable Mr. Justice Manish Chaudhary will now give a brief introduction to this technical session.
Very good afternoon. First, I express my sincere gratitude for inviting me to be part of this particular consultation. This annual consultation involves state stakeholders commission on child protection, which is organized by the Juvenile Justice Committee of Guwahati in collaboration with Department of Women and Child Development from Assam and Mizoram. After 2 discourses on very relevant topics, we are in the third technical session, which is the topic right to fair trial. Focus on child-friendly procedures. We are aware that there are 3 basic tenets of our criminal jurisprudence. One is presumption of innocence until one is proven guilty after the pronouncement by the court. Second tenet is prosecution has to produce case. And third tenet is right to fair trial. Now, right to fair trial is considered to be part of the right to life, liberty, and enshrined in Article 21 of the Constitution of India, and it has been interpreted as the right to access justice, and the right to speedy trial is also part of the right to fair trial. Right to fair trial is not only limited to any stakeholder in trial. Right to fair trial is for the victim, for the accused, for the prosecution, for the witnesses. In fact, the right to fair trial starts from the very beginning and it lasts till line in the trial. In the case of Zahira Habibullah Sheikh versus Sheikh Abdullah, the Supreme Court has interpreted what is right to fair trial, which I must quote here. A trial which is primarily aimed at ascertaining truth has to be fair to all concerned, there is no analytical, all comprehensive, or exhaustive definition of the concept of a fair trial, and it will be made to be determined in seemingly infinite variety of actual situations, with argument object in mind whether something that was done or said either before or the trial deprive the quality of fairness to a degree where miscarriage of justice has resulted. It will not be right to say that it is only the accused who must be fairly dealt with. That will be turning Nelson's eyes to the needs of the society at large and the victim or their family members and relatives. Each one has an inbuilt right to be dealt with fairly in a criminal trial. Denial of a fair trial is as much injustice to the accused as it is to the victim of society. Fair trial is obviously being a trial before an impartial judge, a fair prosecutor, and atmosphere of judicial calm. Fair trial means a trial in which bias or prejudice for or against the accused, the witnesses, or a cause which has been tried is eliminated. So from the interpretation given by Honorable Supreme Court of India, it means that a fair trial should consist of a number of elements. First, an impartial judge. Second, is a fair prosecutor. A judicially calm prosecutor. Absence of any intimidation, coercion, influence upon the victim or the witnesses or the accused. And there should not be any prejudice caused to any of the stakeholders in the trial. Now coming to the theme of this particular session, the focus is on child-friendly procedures. The definition of child has been provided in the Juvenile Justice Protection Act. Definition of child in conflict with law is also provided. In the Act, child is who is below 18 years, a child in conflict with law who has been accused of commission of an offence and who is below 18 years of age. Now the session is basically focused on child-friendly procedure in the context of a child in conflict with law. With these words, I would have with us to deal on the subject more elaborately. Honorable Justice, what does? Yes, so I request Honorable Justice Wardas to deliver the decision and to deal on the subject more elaborately.
The judges, respected judicial officers, dignitaries, it was hearing started just before the session started. We are dealing with children. One, fair trials for all. Children are of special category. While dealing with children, as Mr. Chawla, the judicial officer just said, fair trial, we all know, we have experiences, but I have also prepared a normal fair trial. But after coming in and after hearing this, what I felt, instead of repeating the things, what is now today I feeling from my heart I should express. We all judges, we practice most of us after practice of judiciary. In judiciary, we deal with a number of cases, but of different aspects of life. But when coming for children, we should consider the question of empathy, not sympathy. Whatever the child has done, we should radiate that empathy to the children, so that not only the child, but also his guardian and others who are present in the trial can feel that yes, judiciary has radiated that empathy towards the child, and that will build the confidence. As it was discussed just now, the children are running out. Why they are running out? Because they are afraid. The child of 15, 17 years, without any maturity, then he comes to the court. The ambience of the court makes people see the adults afraid, or talking about educated persons afraid. Why will you consider a child? So in this situation, we have prepared a note, but I feel that instead of discussing on the issue of fair trial, opportunity of hearing, not only to the child, but all the procedures that we did, let us discuss or have a session on how this empathy, not only sympathy, but empathy can be given to the child, all the ways by which a child will feel comfortable and confident in the situation of a trial. The child, whether a weakness or a dependent or a they are all victims. This is my feeling about they are all victims. If they are all victims, then it is the duty of the judiciary to give the confidence of him that he will be protected, like a father is so. And as they ask, most of the children either they are orphans or they are not taken care by their family. But if we can give that confidence on them that they are not in a certain place, but in their family and in their home, then this is the duty of our judiciary, all of the judicial officers who are dealing with victim child, to give that confidence on them that a fair trial will be given to them. Not only a fair trial, they will be considered with empathy. What is empathy? Empathy means sympathy in a much larger connotation, where the person to whom they are showing the sympathy will feel that yes, the person is with me. If we can give this confidence on that particular child, he will not run away. He will feel that yes, as when we were children, when we used to come home, we used to feel secure. Yes, this is the home, no one can disturb us here. We will not be hurt here. That benefit of that security has to be with the child. This is the strongly and we are all judges and judiciary, we know what is the meaning of a trial. I am not going into the technicalities. Let us discuss on this issue.
First, the Act says three kinds of offence. One is petty offence, the second one is serious offence, and the third one is heinous offence. Petty offence is one which is punishable with imprisonment up to 3 years. Serious offence, heinous offence is the one punishment for which is 7 years and more. And serious offence are the ones which is punishable by imprisonment between 3 years to 7 years. Now, to be said that the Juvenile Justice Act has provided how a child in conflict law is to be proceeded with either in the course of inquiry by the Juvenile Justice Court or in the course of a trial by the children court. Insofar as the Speaker of the First Decision has already said that in case of offence, otherwise the act is provided by the inquiry by the Juvenile Justice Act is to be concluded with a period of 4 years. And it can extend it for another period of 2 months. In case of petty offence, this inquiry, in case it is not concluded within the extended period of 6 months, then it has been terminated. Similarly, the provision for serious offences, it is only in the case of heinous offences that the child in conflict law is found to be aged for 16 years. A preliminary assessment is to be made by the board first after a preliminary assessment. If it is found that the child in conflict law is of such maturity, he is aware of the consequences of the act he has committed. In that case, he can forward it to reduce to be recorded in the court. Otherwise, if the board finds that he has not reached that much of understanding and taking into account the other factors, his fate can be decided by the board itself. Now, the question is the child-friendly, the concept of child-friendly in the act is much broader concept. If we see the definition here, child-friendly means any behavior, conduct, practice, process, attitude, environment, or treatment that is human. That is what Brother Justice just said, that it is not only sympathy, but the child in conflict law who is to be treated not maybe in a good victim, but he is also a victim of circumstances. He might be a victim of the circumstances he had faced earlier, because of which he might have been reached a stage to commit such crime. The speakers in our have already dealt with the other circumstances might have forced or provoked the child to reach a situation to commit a crime. So is the empathy or the touch which is required to be given to the children in conflict law is human and considerate and in the best interest of the child. So I request Brother Wardas to legal. Yes, my brother is suggesting
that you are all already there in that. So what more can the judiciary do? Because you have child-friendly court, all systems are there. But what should be done? That we can discuss here. I think to hear our language come from the judiciary is extremely encouraging. And so everything not. The question is how do you kind of incite empathy? What we have seen practice a lot of empathy. Because empathy is supposed to be a regard, but we are always hopeful. What I've seen is that the JJBs, when they're working very closely, especially with the support of cases,
While there are a lot of conversation on special courts, the special courts have addressed all issues. Now what we have seen in special courts is that apart from the posted in roles, number two, in camera proceedings, and number three, whether a lot of these special courts have started no questioning to child. But when it's right on the side, pain is in the have changed in JDBs. So when the appropriate child in Fox case, the inquiry is an JDB. But in JDBs, what we do when we see is that both the child and the sitting outside the same waiting area. Not only that, the entire family, every month, which is quite a big thing. Lawyer there are coming dressed in the uniforms, which can give it a bit open appeal, which the area and opposition not be. Secondly, there is eventually one thing I see is what filters everywhere, especially for the all empty. So that child who has asked for a go out, there is no reason for refreshment. So and the wait time and the JDB is huge. So the child will need to wait for at least 4 to 5 hours with the concern that the time something might first might want to say, and waiting is the most open space outside. So I think that's something which can be changed, and I think the principal magistrates have been doing it along the social work.
Speaks of 3 categories of crimes. We already discussed petty offences, which is punishable up to 3 years. Serious offences up to 3 to 7 years. Heinous offence 7 years to and above. And the rule specifically says there is no apprehension, there is no FIR, there is no charge sheet. It will be a summary trial and not a summary trial. Only the last category, heinous offence, children need to be arrested or apprehended. Then there is Juvenile Justice Board, between 16 to 18, only Honorable Justice was very well spoken about where the case has to go to Children's Court. From that place of safety, and one of the final order from the JJB can be special home, last resort. Then the child should get back to society as normal. The child, in the case of care and protection, child goes CWC, from CWC to childhood, children's home, from the social reintegration back to society. This one slide can speak the entire Juvenile Justice Act. I want to insist again, today morning there is a discussion, why do we send children to observation home? Those who are not supposed to be sent. Petty offences and serious offences, cases up to 7 years of punishment need not be, unless it is for the best interest of the child. But if you go to anywhere, any states, including Karnataka state I come from, I have visited almost all the observation homes as part of my official duty as a chairperson of Karnataka State Commission. Almost 60 to 70% children land up in the observation homes should not be there if you apply Section 8 of the model rules. Unfortunately, there is a serious violation of Juvenile Justice Act happening here across the country. And the principal diversion is embodied here. Principal diversion is to divert the child and children from the judicial systems. Therefore, his early rehabilitation can happen. It will reduce the cases in juvenile justice concerned. As a prevention, we also have mapped the Bangalore city. Bangalore city is growing day by day, and as the crimes as well. So we started looking at the pockets where children are committing offences are coming to the police or observation home. We can only identify there are certain areas, there are more crimes happening among the children. It can be peer group, it can be slum, it can be any other reasons. Its important thing is to prevent children coming from that areas. The presence of DCPO, social workers can be there. Therefore, children will not come out from schools. School is the best place for child to live, child to get educated. If you take care of schools, 100% children are enrolled in schools, there is 0% job to say crime or antisocial element. So education becomes very important, and this mapping will make us understand that focus on the areas where children are moving out from society. Now I'm coming closer to the rehabilitation methods are concerned. Every child will have an aspiration in his life to become a lawyer, to become a judge, justice, to become a police officer, driver, teachers, and so on. When an incident of crime happens, his dreams are shattered there. Police, court, then all that makes his aspiration no more viable. So therefore, as NGO, as social workers, as officers, as judicial officers, we have to see the aspiration mapping of child in the entire process. What was his aspiration? And how do you bring back the aspiration back to child? That's what we call individual care plan. Every child should have an individual care plan as soon as he enters into the system, as soon as he is entered into a child care institution, in the observation home, or wherever it may be. So, therefore, the individual care, we can support the child to bring back his aspiration, what he wants to become, we can support him to become. Incidentally, I came today morning and afternoon here, Yesterday I had to attend a function in the High Court yesterday in Karnataka. One of our inmates enrolled as an advocate yesterday. He's the third one to get enrolled as an advocate who has gone through these experiences of in his life. Again, where should we start the rehabilitation package? The first instance, the first contact place itself. Why the principle of diversion or otherwise, children should be diverted back to the families and society. And we know the causes why the children commit offences. And we have to find ways and means to solve those root causes. If they're hunger, if they're thirsty, if they're poor, we have ways and means to support them. Therefore, ECHO has found a way where children are released from the homes or to the police station or other the CWCs, the family is supported by the ration. Rice, dal, whatever the child requests for a month is given to the family. Therefore, the child does not have to come back to the street again. Perhaps you may know, we run the special home for the Kerala State, ECHO organization. This is the only organization in India managing a special home. And that has become model. Honorable Justice Madhalukur was there a few years before, and he was admiring on that type of rehabilitation package that we do for them. We claim zero recidivism. We follow up every child at the age of 24. So therefore, we have number of programs happening within the special home. Like counseling for both parents is required. Training for the cook is required. You know, very often we talk about trainings. Training is not only for the Juvenile Justice Board members or CWCs or POs, superintendents. A person who works in the last level, a cook has to be trained in order to prepare a good food for the children. Different activities happen in special home. We have life orientation, career guidance, personal development, yoga and meditation, counseling guidance, therapeutic treatment like dance and music. The day starts with the music in the special home, and the day ends with the music. The instrumental music makes the child to prepare himself psychologically, and with the yoga and meditation, that day gets prepared. The day ends with the music, and he goes to sleep without much problems. So even the day planning is very important for a child to get reformed and rehabilitated. One of the programs that leading program that we have, children who have committed offences, early lawbreakers, become law enforcers. They are trained as a traffic police assistants, and they help the police in the traffic junctions. This program has become very popular, and other states also started copying that. What happens here, children who have gone away, children who have so-called lawbreakers, are trained under the police, traffic police, and they are supporting police, and they are paid by the CSR companies in Bangalore. There's supposed to be a video, I don't able to get that. Okay, another rehabilitation program that we have is hotel management. You have seen the video. Now we have different states coming forward to send the children from the different states. This is a one-year diploma program which takes the standard of the child in a higher level in the society. We have a number of other rehabilitation measures like painting, carpentry, and so on, so on. But then very often we find those are not sufficient to bring the child dignity as well as his social status to come up. Therefore, a program like this makes the child to work within the 5-star hotels, 3-star hotels, to travel across the globe and get a better job. This has made a tremendous sea change in the lives of children who have gone through the different difficulties. We have different government of Uttar Pradesh got 39 students. We had sent 72. Just 1 week before we had that enrollment and convocation ceremony. State of Assam, 8. Just now 4 students are undergoing the training with us there in Bangalore, and SOS children 55. Total, bigger number is coming this year as well. I must thank Principal Secretary who has taken a lot of initiative. We keep coming to Assam again because we are also conducting some training for the functionaries in Assam. So Assam becomes a second home for us now. Can you help me with this? This video is supposed to play. Okay. This was the convocation ceremony just happened last week. After the rehabilitation happened, after the employment happens, they are not yet ready to go back to society. At the age of 18 or 19, you all have passed that age. 18 or 19, we are not yet prepared to be alone, single in the society. We need support, we need help. So we formed group foster care homes. Children who are employed, they form a group, they rent out a house every now and then. Therefore, to make sure they don't get back to crime again, number one. Number two, they follow a decent life. They are not, lacking anything. To follow up and to monitor child is also very important. We also conduct training and hand-holding to other states as well. From our experience, our knowledge, we also started helping other states, training JJB, CWC functions and so on. So Assam is one of the states. Is secondary, he went to college. Now he's working in the jewelry where he earns 96,000 rupees per month. This is a story of a child. At the age of 10, his parents were construction workers in the site. And the child was left in the street. He studied with us up to 10th class, 12th class. He has completed all the college studies. He is now attempting for IAS exam. Looking at this photos, you can understand children get into different types of jobs. Some are become bus conductors, some are become department, the excise department, jewelries. So has become a film, and that film entered into Oscar award. Only entered. But that was the film, the 3 children who commit offences. Their story was found. It's supposed to running, I'll just get out of here. There's a film. Let's go back.
It must be in your pen drive, or in certain my pen drive. It must be. You are looking for some video or
Yeah.
in your
Let's look at my story. Will you change the number? Yeah, my device. Success story of a children. No, go back. Just put this one. Yeah. Open it. Not that. Yeah.
Listening to what Manish told us in Bangalore. Suppose you had not been caught by the police.
What do you think you would have been today?
He will be big, I think big robber or some, I don't know, killer.
That was the story of Mahesh. He was at the age of 13, he had 13 cases against him. And he was in the observation for more than 9 months. And his parents were not able to take care of him. He didn't come to observation home at all. And that's the time I was also practicing lawyer. I took up his case and pleaded his case, got him on bail. I came to ECHO. He was a dropout child. Then he started studying formal education, complete 10th class, complete 12th class, complete graduation from the famous Christ University. Now he's a manager in ICICI Bank. At the same time, preparing for IAS. So rehabilitation is absolutely possible. What we need, we have to join hands together with the departments, people, stakeholders, and make sure every child who goes away from society comes back to society with dignity. Thank you very much.
Since we are running short of time, I would now like to request Honorable Mr. Justice Mir Alfaz Ali to kindly share the final remarks.
Thank you, Mr. Sebastian.
And I would like to say, as a humble request, wherever we may be as a social worker, as from all the stakeholders, we can bridge this gap, that the importance of education, where many have not understood, though we have all the schools and education institutions in different pockets, quality of education needs to be bridged to wherever it hasn't reached, and every children out of school can be a child labor or different antisocial elements can come out from there. So thank you so much. I just wanted to share this thought before we depart from this hall. Thank you so much.
There was fantastic discussions. What we can gather is that there is no reason for being disheartened, and the restoration and social integration is possible. What is necessary, we all need to put our hands together to move forward. With these few words, thank you very much.
Next, we will just make a short presentation, introduction to this e-course.
We will now begin the concluding session of the annual state stakeholders consultation on child protection organized by the Juvenile Justice Committee, Guwahati High Court, in collaboration with State Child Protection Society, Department of Women and Child Development, Government of Assam, UNICEF. For this concluding session, we have with us on the dais Honorable Mr. Justice Kalyan Rai Surana, Chairperson, Juvenile Justice Gyanendra Pratap Singh, IPS, Director General of Police, Assam Police, Shri Harmeet Singh, IPS, Special DGP, Assam Police. We also have with us Shri Lakshmi Narayan Nanda, Child Protection Specialist, UNICEF.
Shri Gyanendra Prasad Singh will now be felicitated by the officials of the State Child Protection Society, Department of Women and Child Development.
The officers of the Guwahati High Court Registry will now felicitate Sri Harmeet Singh.
Shri Lakshmi Narayan Nanda felicitated by the officials of the State Child Protection Society, Department of Women and Child Development. Shri Nanda is now requested to present a summary of the key takeaways as well as to give us an introduction to e-course on child protection.
Thank you so much. Just a small correction. I will not do the summary of key takeaways because that will be done by Honorable Justice Surana. What I'll do in next 2 to 3 minutes, I will introduce the course which we are planning to launch it today in this forum. Just give me 1 minute. A very good evening, respected dignitaries on the dais, esteemed participants from all 4 participating states. It's an honor for me to share the space and introduce the e-course on child protection. We are thankful to Honorable Juvenile Justice Committee for giving us the space to introduce this course. This course is an attempt to further familiarize the whole concept of child rights, more specifically the child protection rights. As you all know, 29 out of 54 articles in the UNCRC, it talks about protection rights. The course is open for everyone who is working in the child protection ecosystem, whether as a district child protection officer or PP or anyone, and it's also open for students and JJB, CWC, SCPCR member. So this e-course has provision of 8 modules. So these are all basic fundamental things which we have captured it here. When I look at it, it starts with the introduction to child rights. Then the different organs that we have within the child protection ecosystems. We have also taken into consideration of the latest amendment, that is Juvenile Justice Act 2021, and also the provision within the Mission Vaschalya. Say for example, the changes, the shift from Child Protection Committee to Child Welfare and Protection Committee at the Panchayat level, the 5% use of untied fund that is available with the Panchayat, and also the power that is given to district collector. So all these things we have taken care of, and in each of the module actually it consists of a talk, a lecture method, followed by a small video, and then different exercise that we have, and towards the end there is an evaluation. So at the end you can also get a certificate from UNICEF, and we are now in discussion with esteemed organizations like Assam Police, SALSA, State Judicial Academy, to see that how best we can introduce this course in the ongoing training calendar of this institution, which provide both in-service and pre-service training. As I mentioned, for the first time we are launching on online mode. It takes around 32 to 36 hours to complete this course, and offline version it is maximum 5 days course. So very soon with Assam police, that's what I had discussion with Harmeet Singh sir. And with this, I would like to stop here and then proceed.
Thank you so much, sir. Next, we have an address by Shri Harmeet Singh, IPS, on role of police as duty bearer, Assam Police Shishu Mitra Initiative.
Yes. So, with your permission, Honorable Mr. GP Assam, Mr. Gyanen Pratap Singh, Mr. Justice Mir Alfaz Ali, Mr. Mukesh Sahu, Principal Secretary, Chairperson and members of the SCPCR, senior judicial officers, luminaries from the fields of academia, the social sector, and of course, Madhulika and her team. Lakshmi requested me to speak on the Assam Police Shishu Mitra program, which possibly some of you have heard of and some of you haven't. So today you will. But before I start on what I would say about the Shishu Mitra program, I want to stress on two basic words which I use all the time, and I believe today one of my buzzwords has been the buzzword in this conference, and a lot of people have used it. I had used it last year when UNICEF made a film for the Honorable Supreme Court on child protection on the 10 years of POCSO. The word is empathy. And unless and until all of us, whether who are part of the criminal justice system or who are part of the social sector, or even parents and teachers, every human being, till we look at another human being, particularly a child, with empathy, not sympathy, mind you, there's a huge difference between the two. So unless and until the word empathy comes into what we do, there is no way that we can either provide justice for the child, or can we ensure that those who are in conflict with the law can be brought back on the right path, rehabilitated, diverted, diversion, whatever you want to say. So my request to everybody before I start is that let's think of the word empathy before we do anything else. And the second part is what is used as a social media tag all the time, which we use and which our Shishu Mitra program is based on, is for every child. The entire concept of child protection is for every child. You cannot discriminate. You must look out for every child, irrespective of whether, let's face it, victim, yes, but child in conflict with law also has to be given a chance. So we all know that 40% of India's population are children and young people, and there is a presence in our society of older norms, which some very good, some rigid, but a lack of communication between the older generation and the younger generation. And with the fast growing information age, at times it leaves the younger generation quite confused as to what is right and what is wrong. And it is with that idea that the responsibility comes on all of us to address the issues of children within an adult-centric criminal justice system. You know, Assam saw, or rather sees, almost 5,000 plus child-related cases every year. And we just finished a survey at Shishu Mitra, of which UTSA and UNICEF are our partners. Child sexual abuse, out of 2021 and 22, our survey, we saw that there were 3,387 cases of CSA. Missing children were 4,809. Child suicides were 300 plus. Children in conflict with law were 988. That's not a small number for 2 years. 500 children every year. So when we look at it, we must understand that child-friendly policing has to uphold the rights of children, accommodate law-defined special provisions, adhere to principles and procedures mandated in child-related laws, and affirm to the definition of child-friendly as explained in the Juvenile Justice Act. This is particularly for all my friends who are part of the criminal justice system, particularly my colleague police officers who are sitting here today. Our program has identified some core areas, and we are trying to work towards doing as much as we can. But I must first tell you an anecdote of how the program came up. UNICEF and UTSAH came to me just after I had joined here in Assam, and they came and said, we want to do something. The POCSO Act says that policemen can't or policewomen can't wear a uniform when they go to interact with children who are either victims or for other reasons. So we are designing a jacket, and would Assam police use that jacket? So I said, very nice. We'll have a jacket, we'll have an event. Then after some time the jacket will finish, because in 2 years or 1 year it would have torn, people have stopped using it. And by the way, I think those jackets have disappeared. We have to get the next lot. But this is not institutional change. It's not reform. What do we do after the jacket? Child-friendly policing cannot start and end with a jacket. And that is where the idea of the Shishu Mitra program was born. Of course, we inaugurated the jacket. It was a huge success. The head of UNICEF came. We got a lot of publicity. But then came the real part. And what is the real part? How to guide the policemen and policewomen to look after children. So let's talk of the first thing that we've done. We've set up a resource center. It's called the Assam Police Shishu Mitra Resource Center, or the SMRC for short. From the time that an incident is reported to the time a charge sheet is filed, the idea is for the investigating officers to get guidance through and through on how to handle the child, how to handle the procedures, and how to handle the case. And it has started showing results. Pendency has gone down almost by 78%, and convictions have started coming. But the Shishu Mitra Resource Center can't work alone. So the entire Assam police is transforming. The entire Assam police is changing. So the fact that we are bringing about proper procedures, proper follow of law, proper investigation. There's a huge move towards forensics going on. So Shishu Mitra comes and synergizes with that vis-a-vis the children. Just now we were sitting outside and talking, and the DGP and the head of UNICEF here, Madhulika, were having a talk. And I think we're going to take their help also, and we're going to, on what we do, also add help for women. So women protection. So first is, as I said, the on-call hand-holding support that we do. But then, unless we increase knowledge and capacity, nothing's going to happen. So for knowledge and capacity, we have regular trainings. Until now, almost 5,000 policemen have been trained, but this is an ongoing feature. For this financial year, our trainings are going to start coming September, and every range is going to go through it. Our aim in the next 2 years is to touch every policeman who is on the ground doing an executive job vis-a-vis crime. Even if they are not child welfare police officers, even then we want to make sure that they have the basic knowledge. Regular refresher courses, notes. Lakshmi's been in talks with me, and we're going to do a pilot of this training at the academy and see how it goes. In fact, Nimhans from Bangalore has also joined our effort, and we are going to be going up to Nepa, where our sub-inspectors and DSPs are under training, and we are going to see if we can introduce this course there. But none of this is possible without public outreach. Unless there's awareness, you and I are aware. Again, I come to an anecdote. We were just talking and Madhulika mentioned 1098. So the DGP's reaction was, yes, we all know about 1098, but how many children know about 1098? We have a number called 112 for emergency response. We have another number called 1930 for cybercrime response. But how much does the public know? So together, awareness has to be done. And we are very grateful that the judiciary has offered more trainings to us. We've done one round of investigating officers training with the judiciary. Now we are going to go in for the next round. We are also, so public awareness, one is on the social media platforms. All of you would be aware that our social media platforms are huge. The Chief Minister himself going into the assembly and talking about child protection and Shishu Mitra creates awareness. It brings a buzz. And now what we are doing is we are using our VDPs, our village defense parties, to take awareness about child rights into the villages. And already we've had 12 of these child rights focused programs with VDPs in 12 districts and about 15,000 to 20,000 participants. And this is the next thing that we are spreading. We are not only just doing online work, we also have sessions going on with schools and colleges. So we've covered Kamrup, we've covered Morigaon, we've covered a lot of Guwahati, and now we are going across. Some of this costs money, and we are very happy to see that the British Asian Trust has also come forward to help us with this initiative. Now, question is, have we been able to activate the governance structures, the SJPU? So yes, we have district level plans of action in place, and SJPUs have first came up in Bongaigaon, Gwalpara and Sibsagar and Guwahati, of course. And you know, the conversations that came out of these, an NGO came into Bongaigaon and they set up a child care center. Gwalpara today has child-friendly corners in every police station. And in our Moitri program, which by I think the end of next year or by 26 maximum, all police stations would have been covered and we would have child-friendly corners as mandated by law everywhere. By the end of this year, it will be functioning wherever. It is not functioning today. So I don't want to carry on too much, but I think I've done my 10 minutes. Okay. I just want to bring in one last thing. We've brought in one more innovation, which is you cannot do this without motivating your own people. So we've also introduced something called the Shishu Mitra Awards, which is for police personnel who do well on both sides. Investigation, prosecution, conviction, by setting up a good case, but also rescuing children and helping children in conflict with law. It was a big success, and this year, both in the Chief Minister's medals and the Home Minister's Excellence medals in investigation, 2 officers who have done work with children have got medals there also. So police people, police personnel, all of us are part of society. We equally need that little pat on the back. We equally need help with stress. So part of the Shishu Mitra program is we are also doing mental health series for our people themselves, which is, as I would call, care for caregivers. As the theme is, of course, partly children in conflict with law, I just want to bring to the notice of the Honorable Justice and the House that we finished our survey of from 1st Jan 21 to 31st December 2022, and so we've been able to identify a lot of factors related to children in conflict with law. That's I can just show you that this is the action plan. It's ready, and from next month we are going to put it down into practice. That's all I had to say. Thank you very much.
Thank you so much, sir. I now have the honor of requesting Sri Gyanendra Pratap Singh, IPS, to address the session.
Honorable Justice Surana, and ladies and gentlemen, I just have a few points which I have always felt about this entire issue. One is that always talk about welfare of the children and others. I often come across those police officers. I'm only talking about police officers for now because I interact with them on a day-to-day basis, who have issues with their own children. So perhaps there is a need for all the stakeholders and those who are in this entire profession and this entire business to have a look within. What are they doing at their own houses? What are they doing at their own homes? Because unless and until they become role models, people would not listen to them. Howsoever you may talk about all these things, people are not going to listen to you because they know that you are yourself not practicing what you are professing. That is point number one. Second, my colleague Special DG spoke about missing children. Now this is something that I have been saying for a very long time, that there is a need for the database that has been collected of children through the Aadhaar to be used for identification of missing children. Now if a child who's on the streets and we are able to capture biometrics and then verify it against the Aadhaar data and come to know who he actually is, where is he from? Because we have the database, we have this process where we have been capturing the database of all the children, but somehow there is no structural process by which we can utilize that for the purpose of identification of these missing children, which now the number goes into thousands every year. Child trafficking is one of the biggest criminal syndicates globally. We have the database, but we are not utilizing it because we have not been able to project the requirement for this purpose to the concerned appropriate agencies and at the appropriate level. So I would request this to the Honorable Justice, who is also the chairman of the committee, to bring it to the notice at the apex level, so that for this limited purpose of identification of the children, we can use their biometrics to be run against the Aadhaar database to identify who they are. Otherwise, it's a very long process. You keep on going through the police processes and send a WT message, send a notice that this child has been recovered, and then only 5-7% get identified and reunited with the families. So this is one thing that I have always thought. A couple of things about this entire issue which come from my own experience. One is that I have been observing that now the children in conflict with law, the number has been increasing of those who are substance abusers. Now this is another major area where we have to get into, because they come in conflict with law because they have started consuming drugs. So there has to be a joint process wherein we can stop them from getting into that, because once they get into the drugs, now every day Guwahati, those who are from Guwahati or some of the other towns and cities of Northeast, they would have heard or read in the newspaper that a large number of chain snatching is going on. Now chain snatching, when we make an analysis, we see that most of the guys are below the age of 18 and most of them are drug abusers, substance abusers, and they get into it because they have to get money for the drugs or substance, whatever that they are abusing. So there has to be a comprehensive strategy for this so that we can take proactive preventive measures for this. Next important issue where we have to proactively think of is that what would be the impact with the increasing number of enabled smartphones. Now when we come across various kinds of hate mails, hate speeches, or social media posts that are spewing venom against various people, systems, or talking about likelihood of committing crime and all that, we see that there are a lot of children. So now, becoming almost universal. Now this is again something on which all the stakeholders have to apply their mind, how to sensitize the family members so that they are in a position to teach the children what is good. Just like we had for a long time this entire exercise about good touch and bad touch for girls. Similarly, we should have good usage of as I see over the period of next 15-20 years, we would not be seeing the street crimes being committed. These kids would be sitting at home and then they would be committing crimes. Now, we have to identify who are par excellence. We can use them. System can use them, private agencies can use them, but since there is nobody to use them, then they get into this. So these are the emerging trends for criminal CCLs and all that. So we have to take proactive measures on that. Most of the things about the Shishu Mitra scheme, my friend Harmeet has already spoken about, that's doing well. Again, I have just a small suggestion about the Shishu Mitra scheme as well. That is, all the stakeholders in the Shishu Mitra scheme, they should also identify police officers who are actually good towards children. And they should be taken into it rather than spreading the too far and too wide, because see, everyone cannot do everything. So there would be some people who, as Mr. Harmeet Singh spoke about empathy, there would be a larger measure of empathy towards children. There would be some people who would have empathy towards women issues, and then there would be some who would have who would be interested in various other issues like counter-terrorism or syndicate operations and this and that. No point wasting energy on them. We should identify those people who have empathy towards children and who want to work in this entire specific area, and they have this feeling that they are doing a good job. A large number of police officers and other agencies, they feel that they are bogged down with this additional work. So we should identify such people and utilize them. As all of us know, this is an area which requires a lot of attention, especially with 40% of the population and the demography being young. We have to concentrate on this area, and I'm grateful and glad that everyone has come together and we are having this discussion. And whatever comes out of it, if even substantial part of it is put in practice, things would substantially improve in Assam. Thanks, God bless.
Thank you so much, sir. Finally, it is my pleasure to request Honorable Mr. Justice Kalyan Rai Surana, Chairperson, Juvenile Justice Committee, Guwahati High Court, to deliver the closing remarks of the annual state stakeholders consultation on child protection.
Thank you. And I think it will be a relief to all of you to know that this would be the last event of the day. And so far as I could understand from the deliberations, that number one, it's eye-opener for at least me. Not that I'm not aware of the various provisions of law, but it is good to be reminded that this is a good practice and therefore has to be followed. My thanks and welcome to Mr. Gyanendra Pratap Singh, the Director General of Police, Mr. Harmeet Singh, to be here in this session. My sincere thanks to Mr. Mukesh Kumar Sahu for being here for the entire day. My brother Justice Alfaz Ali to be here. To bring home the points which we have been discussing. So far as I have understood, in the topic number 1 of child in conflict with law, prevention and early intervention, the main thrust was the identification of vulnerable families, linking them with the social protection scheme, and using provisions of sponsorship under the Mission Vatsalya needs to be given a close look while designing the planning of prevention and early intervention. Activating community participation and interaction with such vulnerable families so as to ensure that the children are not coming into the conflict with law. To make an attempt to find out if there are any organized gangs who involve children in crime and or criminal activities, so as to stop this menace of children being drawn into the conflict. Encouraging such child to go to school where we have in the state of Assam the facilities of midday meal which can be provided. This would and also to encourage the potential children who would be in conflict with law to be engaged in sports activities. Insofar as the second topic is concerned, relating to principles of diversion with emphasis on non-custodial alternatives, we have all heard about diversion. I would not repeat it again, which in short would be avoidance of judicial process, divergence from jail, to ensure that the juvenile justice boards should use its powers and responsibilities as envisaged under Section 8 of the JJ Act. And focus on child-friendly procedures. The thrust was on to ensure that the procedures for a fair trial is to be followed, to follow the provisions of Section 17 in respect of child not found to be in conflict in law, to pass orders by the JGVs as provided under Section 18 for the child found to be in then assessment of juvenility, and ensure that Chapter 3 of the rules be followed. For topic number 4, which was minimum age of and preliminary assessment, we've all come to know that there's a child in conflict and the age of criminal responsibility is to assess the child within the window of 16 to 18 years, and they are to be properly assessed and heard. Fifth goal, as referred to by Mr. Anthony Sebastian, is that we should restore the last topic which we are taking up today and addressed by the DGP and Mr. Harmit Singh, was with regard to the Director General of Police had referred to missing children. What comes to mind when I read newspapers, especially the Assam Tribune, child and women being missing in Udalguri district. That is one of the districts I find every few days advertisements of missing children and women, especially, and concentrating to Udalguri district as a high. So I'm glad that the police has taken note, Assam police has taken note of this missing children and women, and definitely steps once the issues are identified. With these few words, I thank you all for being here for the entire day, and thank you so much.
Thank you, Your Lordship. With this, we have come to the end of today's program. All dignitaries, distinguished guests, and participants are requested to join us for a cup of tea. Thank you. Good evening.
Thank you.